Items for pronouncement of judgment. Item number 16, MFA 153 of 2003.
Appeal dismissed. However, the rate of interest is modified to 9% per annum.
Item number 17, transfer petition criminal 5 of 2023.
Petition dismissed.
Mention.
Yes.
Hello, dear Lordship, may be kind enough to allow me to move a review petition tomorrow. Urgency in the sense, my lord, taking advantage of the order of this honorable court. My lord, the other side, my lord, has broken the boundary wall. And in the vacation, my lord, the Lordship can understand what they can do.
Tomorrow only one court will be sitting.
Well,
Okay.
much of this.
My lord, beg to mention item number 3. In this case, my lord, I am appearing for petitioner. Private respondent number 5 has filed affidavit. I received on 1st of October. I may be allowed to file reply.
On the pair being made by Mr. N. Sarma. SSL lists the matter after vacation, so as to enable him to file a reply to the affidavit in opposition filed by respondent number
5.
5.
Date may be fixed, my lord.
When?
Date.
On first, in the first week of November, on 4th November.
Your place. May I please, Lordship? Lordship, may I pray for listing of this matter on tomorrow, Lordship? It was filed on last Monday. The urgency is that, Lordship.
I have already stated that
Yes, Lordship, I
tomorrow
can
only one
understand.
court will
But
be
since the
sitting.
urgency is there, Lordship, in this particular plot of land, we are holding the Durga Puja for several years. Now the opposite party has filed one land grabbing case with regard to same plot of land. One civil suit is pending with regard to declaration of right title interest and partition. Now we file an application section 10 for stay of the.
When the land grabbing case was filed,
That was in the year 2019, Lordship. Now they are intending to stop the petitioners to hold the Durga Puja, Lordship. And this is not the issue, but the fact is that, Lordship, when you file an application under section 10, that has not been considered. So we are apprehending that we may not be allowed to hold the Durga Puja this year, Lordship. And with the prayer for stay of that particular order, Lordship.
okay.
Lordship.
But you have to take the risk that your matter may not reach tomorrow.
I will
Lot
take a
of
chance,
matters are there.
I will take a chance.
With the consent of the opposite side, I beg to mention item number 12. It may come after 10th November.
You are for?
I'm for NF on behalf of B. Sharma, standing counsel NF. Respondents.
Have you taken the consent from other
Yes,
side?
yes,
Yes, my lord, I am appealing for the other party. My lord, I understand the personal inconvenience. My lord, from last two date, the date was fixed by them. My lord, a final date may be given in the matter.
To 10 November.
10th of November. As agreed by learned advocates of both the parties, races and list the matter on 10th of November.
Lordship, 10th is Sunday. On 20 November. On 20 November. Oh, it's a hearing matter. On 26 November. On 26 November.
My lord, if it can take place on 19th November,
Okay.
26 November.
26th November.
Also, we have to mention listing on regular bail application. Earlier it was rejected by Lordship. Lordship, urgency is that one of the co-accused whose bail also rejected by this honorable court. But recently Supreme Court enlarged him on bail, Lordship. On that ground, Lordship, we have to take a chance for tomorrow, Lordship.
During vacation, Lordship? During vacation on 8th.
No, by this honorable court. This matter should-
Tomorrow this court will not be sitting.
Then vacation, your Lordship, be. Oh, I'm okay, sir.
Please, your lordship.
Hmm.
Lordship, in item number 18, we filed an affidavit, additional affidavit.
Item number 18.
18, so that must call for lordship.
Okay. Okay.
Lordship, I beg to mention several very old matters, all of them not listed in last 3 to 5 years.
After vacation, you can take any date from him.
Much of that. Any,
Give the nation memo, we'll give the date.
My please, Lordship. Lordship, item number 9, matter is fixed for hearing, but what happened, Lordship?
both respondent number 3 and 5 expired.
You inform the other side.
Yes, so I am for the other side lordship, for the appellant lordship regarding respondent number 3 lordship.
Hmm.
For him.
Expired on 20 May 2023, unmarried, there is no legal hand.
So name of the respondent number 3 may be struck out lordship because she has no legal heirs lordship. And regarding respondent number 5 lordship,
I don't know name of the legal hand,
so I need some time to inquire and to
Okay.
file
Okay,
substitution.
okay, as agreed by learned advocates of both sides, the rest shall list the matter after vacation on. Okay,
27 November,
sort that, Kobe, this is a 2008 matter.
on 14 November.
Lordship, after substitution of respondent number 2, then notice was not sent to legal heirs.
We will not examine the matter now. On
After
that day, you raised the issue.
On 14th 14 November.
May please your lordship regarding item number 10 lordship. This is also hearing matter lordship. Let the matter come up after vacation lordship.
Did you inform the others?
Yes,
No,
other
I'm-
side is there.
Okay, as agreed by learned advocates of both sides, the rest shall list the matter after vacation.
Apply.
On 19th November.
It please, your lordship. Lordship, in item number 1, I have filed my affidavit today, your lordship. Kindly that may be called for your lordship.
Okay,
Obliged.
Yes, Mr. Lordship, I think indulgence will mention this matter as unlisted matter. What happened, my lord? CRPIO one is pending, today is item number 57 and code number 24, my lord. Because one order was not challenged, that is why another CRPIO is as by instruction of this honorable court, my lord. It was filed, my lord. If your lordship allowed it, it will be back with that, my lord, unlisted. And notice will go then, because my lord, issue is that the inventory right was shot in the plot number 3, which is belongs to another.
Oh, oh,
Our plot is not scheduled,
no, no,
part of
when
the
the
schedule,
other matter is fixed,
my lord.
the
Okay.
other matter is fixed,
Yes, 57, item number 57, it was.
when,
filed
no, in whose court?
Today, my lord, your lordship is allowed, then it will.
Our court, when?
Are you praying for today's?
Yes, my lord, that will take together, if notice will send, then if you are allowed, if lordship allow, otherwise after
No,
vacation. my
no,
lord-
when the next matter is fixed,
My lord,
the other matter is fixed
today, my lord.
today, in whose court?
Court number 24, Honorable Justice. Bollywood.
Okay, okay.
Obliged, my lord.
May please your lordship. I have to mention for listing lordship. After vacation lordship, MSC appeal number 114.
Okay, take a date for me.
Item number 20, upgraded matter for hearing.
Arts one, yes, sir. Next matter.
For admission, item number 1.
After some time,
May I please, your
okay,
lordship? Lordship, Mr. A.R. Bhuya could not appear due to some serious health issues, so kindly the matter may be posted after vacation.
okay. As right for by Miss
A. Bora.
A. Bora, learned counsel appearing on behalf of Mr. A. R. Bhuya, learned counsel for the petitioner. Rest shall is the matter after vacation. Okay.
Obliged.
Item number 2.
Lordship, lordship, matter will be taken over after vacation lordship.
Why?
Like K. Gogoi lordship, he is appealing lordship. But I mean, I talked to him, the record has come lordship, but some problem, record is sent back again lordship. And because the record is coming lordship, this is request to after vacation for final hearing lordship.
My lord, possibly at this stage, what, if your lordship permits, my lord, I'll take only 1 minute.
Yes.
Record may not be required. What happened, my lord, in this West Golfara College, there was a selection for the principal. Private respondent who was in the writ petition
she was appointed, but ultimately she left for another college. Serial number 2 and 3, they were not interested. We have made them party. They have received the notice, but they did not appear. I am serial number 4. So at this stage, what my prayer will be, my lord, if the education department just redo the exercise and if I can be considered, because I am the next in the fray. That is my only case, my lord. If my other side, private respondent doesn't object, my lord.
You are for?
Lordship, I'm from higher education, Lordship. I will appear on the K. Gogoi, Lordship.
Mm.
I'm sorry, because he's some person difficult or something. That's why without him,
So why record is necessary?
but Gogoi is conducting the case, Lordship. That's the problem.
My
Lordship.
lord, I appear for the private respondent.
Private respondent.
And I was selected and appointed, and the records were called for to see, my lord, because my educational qualification has been, my lord, questioned.
Mm.
That's why the court wanted to see the records.
Mm.
But my lord, the submission made by my learned friend that, my lord, my client has left the college, my lord, I don't have any instruction on that. That is what he said. I don't have that instruction, that he left the college.
Let after vacation, Lordship, in the instruction, and Gogoi will take the Lordship. That will be better. Immediately after vacation, Lordship.
She has already joined in another college.
Immediately after vacation, Lordship.
So without instruction, you are submitting before the court.
To me?
Yes?
No, 100%. She has gone. I have said in my affidavit, and then I made the other 2 persons who are serial number 2 and 3 party. They have been, notice has been issued on them. They received the notice.
But
It
the
is a long
counsel
process.
for the private respondent,
That
There's no
also, my lord,
instruction.
that I'm surprised to hear that, my lord. Actually, my senior counterpart has said that he has got no instruction. That is surprising because she has already joined in another college. We have given the assertion, my lord. I know it because I'm an interested party. If she's there, I'm nowhere. If she's not there, then only I can make a prayer.
okay.
Now, what my lord, I made the prayer to the department should rethink about it. If she's there, I cannot make this argument also. What is the question of rethink if the post is not there? The post is there.
Mr. Sharma, you obtained necessary instruction from your client?
After vacation, Lordship.
Okay. As agreed by learned advocates of both the parties. Rest is on the- We'll fix a date. Okay.
On 30 of 30th October.
My lord, could it be 29? We'll try to finish it off, my lord. If this is
29,
the
my lord.
scenario.
Okay, 29.
29.
29.
Obliged, Lordship.
Deeply obliged.
Item 18.
In the meantime, Mr. M.K. Sharma learned significance for the respondent number 5 shall obtain necessary instruction in respect of this client leaving the college.
May I please, lord.
Yes.
Also, this is regarding the Rashtriya.
Yes.
My lord, I have
Whether
received.
Mr. Gupta is available?
He was here, my lord. They made a mention in the morning. They filed an additional affidavit in opposition.
Yes.
Pursuant to the queries made by this honorable
Yes,
court, my lord, I have got a copy. They made a mention in the morning to bring the affidavit on record.
Yes.
No problem, he was here. He is coming, my lord.
I see.
I have filed the additional affidavit, my lord. Requisition it, my lord. Can it be taken away too, my lord?
Okay.
My lord.
But my lord, what information were sought for by this honorable court has not been
No,
diverse
there,
in
my
this
lord.
affidavit, my lord.
Everything is there. I will.
No, my lord, I have gone through the affidavit.
Yes.
My lord, the queries, specific query was there, whether there were 27 students as on today in school, in place of
Yes,
28.
that is.
They have not said that as on date, there are 27 students, nor they have denied that there are not 27 students.
No,
They
that-
made a very categorical and very tactful answer, my lord. They say, if any vacancy has arisen, that will be adjusted in the subsequent admission session.
No, that
That is
student
the
has-
stand.
Let me.
No, no, yes, I am.
That student has gone, my lord. The query which lordship has asked on the last occasion, whether the candidate, one of the candidates has withdrawn or not. He has withdrawn, yes.
Yes, in that case, why you cannot accommodate him?
my lord, because of the nature of the course, my lord, because half of the course is over.
No,
And
no,
as-
how? If the
as-
session started September,
My lord, it is almost October, my lord. In
yes,
2-3
how,
months.
how half of the session over?
And as per the policy, my lord, once the student vacates, in case
No,
somebody,
what policy? What policy is there?
my lord, that goes for to the next vacancy, next year's vacancy.
Where is the rule?
That I have, my lord will take it up to affidavit I have filed. it.
You have to show the rule.
My lord,
Okay.
my lord,
Okay,
My
at
lord.
2 p.m. Okay.
my lord, my lord. Obliged, sir.
For bail hearing, item number 4.
But in this case, lordship, he did 1,075 days, lordship.
Hmm.
And the bar lordship. On the last occasion, lordship, is considered whether the evidence 1 or 2 examined in the court, lordship,
Hmm.
but is found in the recorded 1, but the 2 evidence examined in the court, lordship.
Lordship, we are filing our objection today. We couldn't file our objection because the other petitioner's number is not there in the petition, so we could not serve the copy. So I may be allowed to file our objection today.
Which copy?
In the petition copy, the number was not there of the petitioner's counsel, so we couldn't serve the copy.
Lordship, in the last occasion, only having a question whether 1 or 2 of the accused.
You are for?
And for the NCB.
So, Mr. Dubey, you have not furnished the copy of the petition at the time of serving notice?
Have already given, lordship.
Your Lordship,
This
the
is-
petition is there, but the contact number is not there, so we couldn't serve the copy.
What contact number?
To serve the copy of the objection. We need to contact
Lordship,
them.
without giving contact number, lordship, will not take the in the file, lordship. And for the morning, lordship, on the last occasion also, I am in the court, lordship. They already stated that they are going to file objection, and already confusion is there whether one request is examined or 2, lordship. That's why the order give, one order should be passed, lordship, in the trial court, lordship.
You have already filed objection.
No, Your Lordship,
They
we
have
are
not
filing
served the
today
copy.
because we couldn't serve the copy now. That's why we couldn't file. On last occasion, we were searching, but we couldn't find the
Okay,
other counsel.
Then let it be common tomorrow. Tomorrow. Heard Mr. Dubey, learned counsel for the accused, and Mr. Yogunen,
Agent.
AJ, learned counsel for the standing counsel. Are you standing counsel?
On behalf of SC Care.
Where Mr. Kyle is?
Your Lordship, he's on legs in court number 1.
Let him remain present in the court after some time.
Hello, bless.
Item 5.
May I please your lordship? 439 approved, your lordship. In this case, lordship, charge sheet submitted, lordship,
Hmm.
and petitioner is inside the jail since 12/7/2021. Today is about 3 years, 2 months, 8 days, lordship. In this case, from my position, nothing was recovered, lordship. It was recovered in a lordship,
You are for 3 years?
lordship,
3 years?
3 years, 2 months, 8 days, lordship. Some contraband were recovered from lordship, a courier,
Hmm.
then from a parcel lordship, then they prepared a dummy parcel and sent it to Dimapur, and one of my co-accused lordship, one of co-accused in this case lordship, They, along with her, I went there, and from there, showing the note lordship, she wanted to receive it. At that moment, when the dummy person received, that time, this accused person along with the lady lordship arrested lordship. And since then lordship, I'm inside the jail lordship.
Oh, we have called for the scan copy of the record. But the office
Yes.
note indicates that a scan copy has not been received. Sort
We-
that. Sort that means our.
Just after you.
After vacation. Office note dated 30th/9/2024 indicates that scan copy of the record has not been received from the learned trial court. Accordingly, it is provided that Restes also reminder to the learned trial court for transmitting the scan copy of the record forthwith. List the matter on
On 23rd October.
23rd October.
In the meantime, they can file the objection also. Lordship.
We cannot compel them. They may file it or may not file it.
Lordship.
Much obliged.
Obliged.
Item number 6.
Last occasion, Jolot was directed to obtain instructions for the
Today morning, I have received that instruction receipt on WhatsApp also.
Hmm.
But they could not collect the medical report as well as the. So they have mentioned that this vehicle is involved in the. This vehicle is involved,
Hmm.
but they could not collect the medical report.
Medical report of
The one person has been injured, got injured lordship because of this vehicle tried to when there was an Akashiking was going on lordship, and they asked just tried to stop this vehicle, and then this vehicle hit
the case diary is available with you. Is there any material against him?
lordship.
Is there any material against him?
And that I could not because they have also there was also one query was there lordship whether there one phone number has been given by the driver of the truck lordship who was carrying that.
You answer my question. I am asking you whether material is there in case diary against the present
Directly
applicant.
no direct material is there lordship because but
Pardon?
no direct material I have not found lordship.
Hmm.
And direct implication I have not found, but the vehicle truck owner, truck driver has given one number that this number we contact for bringing this cows lordship. Thereafter, as per police, police is sent for CDR that they have not received CDR ticket lordship. Lordship may pass in the order.
No, you carry out the investigation. If you find material against him, then you can file search it against him. At this stage, if there is no material, why custodial interrogation is necessary?
You can try, but investigation will be done by the IO also.
That's all right, but
Is there a report of
when
it?
the case was registered, it
Just
was in the year
23.
2023, you got sufficient time for investigation.
Even on last occasion also, I talked with the OC also to
Mm.
at least to collect that CDR and medical report, and that
Mm.
they cannot collect. Then what can we do also? We can.
This is second application or
No,
first
no, it
application?
was the first application.
Mr. Sophia, learned counsel for the applicant. And also heard Mr. Loskar, learned as state respondent. This application under section 482 of BNSS 2023 is referred by the applicant Nisar Ahmed, who has been apprehending arrest in connection with Makum PS case number 68 of 2023 under section 120B, 833, 253, 307 IPC, dated section 11, 1D of Prevention of Cruelty to Animal Act 1960, dated section 13, 1 Assam Cattle Preservation Act 2021. It is to be noted here that above noted case has been registered on the basis of an FIR lost by one. Where is the FIR?
FIR lodge will find it page 13 lodge, particular FIR lodge, page 13 lodge. And the answer copy of the FIR page 8 lodge.
On the basis of one FIR lost by one Roman Sharma on 8/6/2023. The essence of allegation in the FIR dated so and so is that on 8/6/2023, the informant Roman Sharma lodged on FIR with the Macomb PS, stating inter alia amongst others that on 8/6/2023, during the time of night patrolling at Hukan Pokuri Road, Tinsukia at about 4 a.m., he had noticed that a 14-wheeler truck coming from Dumduma to Tinsukia side in a high speed. And also found one Scorpio vehicle escorting the truck and another Hyundai white colored vehicle in the backside of the truck suspiciously. Then the patrolling party signaled them to stop the truck, and at that time, the two numbers of four-wheeler car suddenly fled away towards Tinsukia. And after conducting search in the truck, they found 20/25 numbers of cow carried in the backside of the truck. On being asked, the driver said that he, along with two unknown persons, loaded the cow, which was situated about 30 kilometers east to the spot, and carried the same towards Shillong. The person who were fled away in the two numbers of car is one Saiful Islam, but he do not know the name of other persons. Thereafter, they have apprehended the truck and the driver and seized the cow being carried in the truck. Thereafter, the informant came to know that the owner of the Hyundai Aura car is loitering at Macomb Bypass Road. Then a nakasaking was conducted by SI Rituparna Dotto and his staff. And the suspected Hyundai Aura car was coming towards Tinsukia to Macomb Bypass. And then nakasaking party tried to stop the car, but the driver of the car instantly increased the speed of the car with the intention to knock down the Naka party and to kill one of the staff, namely A.Z. Dipankar Saha, as a result of which Dipankar Saha got injuries and he was taken to hospital for treatment. Mr. Superior Learned Counsel for the applicant submits that the name of the applicant find nowhere in the find no mention in the FIR. And he is also not involved with the offense alleged in the FIR. And that he is ready to cooperate with the investigating agency. And therefore it is contended to allow this application. Whereas Locker learned additional PP submits that he has received the case ID, but there is no direct material against the present applicant. No, though there is no direct material against the present applicant yet. Some materials are there to show his complicity with the offense alleged. And that the IO could not collect the injury report of the victim and also could not collect the CDR, SDR report of the mobile number 9365831 007021522787 and 863883085.
As well as ownership details. As well as ownership details of the vehicle also. From transport.
And also the ownership of the vehicle, ownership of the truck,
That vehicle also, that one Scorpio vehicle was there also.
and also could not ascertain the ownership of the Scorpio vehicle. And therefore, Mr. Locker, learned additional PP, has opposed the petition. But having heard the submission of learned advocates of both the parties, I have carefully gone to the petition and the documents placed on the record and also perused the case ID with the assistance of Mr. Locker, learned additional PP. Admittedly, there is no reference to the name of the present applicant in the FIR. Two, the driver of the vehicle had stated some phone numbers, yet the owners of the same could not be ascertained by the investigating officer. And the CDR of the said mobiles also could not be collected. Further, the injury report of the victim is also not made available, though the occurrence took place more than a year back. Having considered the submission of learned advocates of both the parties and also considering the progress of investigation as well as the materials collected so far in the case daily, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees, in the event of arrest of the applicant in connection with Macomb PS case number so and so under section so and so, he shall be released on pre-arrest bail on his executing a bond of rupees 50,000 with one surety of like amount to the same. The above privilege is however subject to the following three conditions. Last condition, shall not leave the jurisdiction of CJM Tinsukia without prior permission.
Item number
Case there will be returned.
19,
Item number 19, we have not received the CD also.
Page number 10 is the my lord FIR, my lord. There are lab FIRs between two young boy and girl, my lord.
Let the city come.
My lord, kindly peruse the my lord for considering the interim, my lord, because the long vacation is there, my lord. My lord, page number 17, my lord.
No, these
For interim.
allegations are serious.
Only 15 days before her attaining the age of 18, they eloped, my lord, voluntarily, my lord. And after completion of 15 days, my lord, when she attained 18 years, my lord, page number 17, my lord.
No,
they
even
entered
if her age is below 18 years by one day,
Yes.
then also the offense is completed.
Is 16 years, 11 months, 16 days lordship.
No, I have very
You
clear.
have to complete it
I have
by.
very clear,
As per direction of on the other day.
Item number 7 for orders.
Please, your lordship, it is immediately on reopening date, madam. I have missed the file somewhere, 21st of October, madam.
My lord, the matter is a covered matter, admitted matter, and the date was fixed by the appellants itself.
Yes, madam. but I
And
have
4,000 rupees matter only, my lord.
But leave the point, legal point, for none other the matter of the 4,000, madam. Legal point is there, so immediately on reopening date, madam, 21st of October.
Legal point is also covered, my lord, in this. Everything
Ms.
is
A.
covered, my
Gaya,
lord.
learned counsel for the appellant submits that she has left the file somewhere and prays for little accommodation. There is accordingly allowed to list the matter on 21st
Master.
October. It is being clarified that no further chance will be granted to her.
Much
Master.
obliged.
Item number 8.
May it please your lordship, my lord, it is regular first appeal. My lord, in the steps has been taken, service report is awaited. There is an interim order, so my lord, if your lordship can kindly extend that. Interim order dated 20/12/23.
Word Mr. P.K. Roy Chaudhary, learned counsel for the appellant. Office note dated 3/2/24 indicates that service report has not yet been received. And neither the ID card nor the unserved notice returned. In respect of service of notice upon respondent number 1. You have to take fresh step or we will await service report.
My lord, let us await service report. because-
Okay. Rest shall list the matter immediately after reopening of the vacation, awaiting service report upon respondent number 1 to 8. Rest shall also issue reminder to the learned trial court for transmitting the record without further delay.
In the IA, my lord, the interim order to continue.
Okay, in IA you take down heard Mr. P.K. Roy Chaudhary, learned counsel for the applicant. Interim order passed earlier, stands extended.
For hearing, item number 11.
Respondents are not available, my lord.
Not available.
Not available, my lord. Kindly matter will be taken after the vacation. Time for the appeal.
None appears for the respondents, though Mr.
D. Burwa, lordship.
T. Borwa.
D.
D. Borwa, learned counsel for the appellant present. Who is appearing for respondent?
M. Ali.
But the name has not been reflected in the cause list.
Earlier occasion, my lord, they were appearing. Then registry may be directed to reflect their name, my lord, in the cause list. Number 9. That's why, my lord, they are not appearing. Number 9. আগতে আছে নহয় সেকেন্ড বাই অৰ্ডাৰ আছে উদ্যোগ কৰি দিলাম
No, on the other day, one T.K. Bhuya was present. T.K. Bhuya for respondent.
টিকে ভূঁইয়া learned counsel
For respondent.
for respondent বলে আছে। তার নাম আছে না টিকে?
list the matter after vacation, my lord. In the meantime, I will discuss. If you will not appear, my lord, we will take the first step. That will be better, my lord.
Okay. আগৰ তো clear. কি কলো মই? List the matter immediately after reopening. Reflecting the name of the counsel for the respondent in the cause list.
লোকালের নাম আছে না
You check the record if Okalandama is filed on behalf of TK Bhuya.
Item 13.
Sir, I am for the appellant, my lord. Today the date fixed for hearing, my lord, but I have gone to the office to my lord. LCR has not been received.
Third, Mr. T.U. Laskar, learned counsel for the appellants. And Mr. Gogoi for respondent number,
Lordship. Phone number, Lordship. 4, 7, 8, and 9, Lords.
4, 7, 8, and 9.
Lords.
And Madam, you?
Respondent number 1, Lordship.
1. For respondent number 1. Office note dated 28/8/2024 indicates that LCR has not yet been received. Accordingly, it is provided that SSL issue reminder to the learned trial court for transmitting the record without further delay.
Apply. Item 14.
My lord, in this matter, I am appearing for the sole respondent.
None appears for the appellant on call. How about Mr.? Your good name?
D. Rathi.
D.
D. Rathi. Rathi.
Learned counsel for the respondent present. Place the matter immediately after reopening of the vacation.
My lord, again in this matter, the same similar question of law with the previous case had the same similar question of law, and the question of law is covered and also admitted matter. My lord,
Okay, on
admission.
21st.
My lord, same previous order may be recorded since admission hearing date was fixed by them only.
Okay.
Yes, my lord.
Along with item number? No, along with that number of the case.
Item number 7.
Item number 7.
Much obliged.
MFA number 20 of 2023.
Item 15.
Please, your Lordship. The last provision, my lord, your Lordship fixed the matter for final disposal today because there was an application for modification of the interim order. And,
Mr. Roy Sodure perhaps appeared. Kobe, inform Mr. Roy Sodure. অলপ আগতে আছিল তো
Before the holidays, everyone is busy in motion and
no one is ready for hearing. But unfortunately, today is the date for hearing.
In fact, on the last occasion, he prayed that let it come immediately after vacation, but your Lordship thought that no, it have decided already.
No, he insisted that it should be vacated.
Yes.
Therefore,
Okay, this is against concurrent finding of fact. Therefore, my lord, I have to take your Lordship and try to satisfy your Lordship, my lord, that there is perversity in the my lord findings. That is the primary issue. And two, my lord, substantial questions have been framed. Substantial questions were framed on 13th of March.
23.
Whether the learned courts, both trial and first appellate, by failing to appreciate the pleadings in the plaint as a whole, committed perversity in dismissing the suit, holding that the plaintiff has not been able to prove his right title and interest over the suit land, construing the Kacha deed executed on 14/1/2003 as the title deed on which the plaintiff has based his claim.
So that is on private, Parvur City. And the subsequent question two, whether in view of admission made by the defendants that the suit land was a part of the joint property belonging to their grandfather and the father of the plaintiff, and the fact that out of said joint property, their grandfather during the lifetime had sold his entire share of the said joint property. The plaintiff was required to prove this right title and interest over the remaining part of the said property. Now, my lord, the brief facts, my lord, where the dispute arises is that the father.
Minute. I see Mr. P.K. Vasudevan will argue the matter. We live in another court, my lord.
What to do?
Time-
Shall we proceed?
My lord. Just for time being, my lord. Possible.
This is the last item. Last item in the list. They will come after vacation, my lord. If you agree.
Okay, as agreed by learned advocates of both sides, recessal is the matter immediately after reopening of the application. Interim order passed earlier shall continue till then.
All right.
Or matter.
Item 21. 21.
Please, Your Lordship, we can pass over the matter for the time being, Your Lordship.
Timing,
Yes, Lordship.
but we have almost finished.
Your Lordship, then can you give us a date shortly after vacation?
Timing, no, divorce case तो ऐसे नहीं है, divorce तो something. Okay, let Mr. Das come.
Yes, Lordship. Obliged, Lordship.
22.
I'm the respondent insurance company.
Pardon?
I'm the respondent insurance company.
Respondent?
Insurance company.
So is this. Is the counsel for appellant available?
I've not seen.
You have not seen. Did you try to find out that judgment? That Maharashtra case?
I have another judgment. Surendra Kumar Arora versus Manoj Visla. And
The question was on the other day, whether the accident took place due to use of the vehicle or not.
use of the vehicle, then they have to file the application under section 163A of the MBA. And they file the application under 166 of the Act. And in under 166, it is the duty of the claimant to prove the rash and negligence driving of the owner or driver of the vehicle. Here, from their evidence, what they have adduced from the FIR, final report and the evidence of the IO, it was reflected that there was no rash and negligence driving on the part of the owner cum driver of the vehicle. Therefore, the learned tribunal had granted compensation on section 140 of the MBA. Actually, this application lies under section 163A of the MBA, that is use of the vehicle mirror.
Okay, do you have that number? Okay, let Mr. Das come. We'll see. Mr. Sharma, we called you.
Yes,
but,
my lord, I am sorry, my lord, I am
I could not have at the time, my lord. Other party. I could not
Other
contact.
party was present.
Yes, yeah, present.
Yes.
Yes, I am sorry, my lord. I am sorry.
Anyway, Courtmaster will inform her. We'll sit at 12 o'clock
Yes,
after half an hour.
yes, sir. Yes, sir.
You remain present.
Yes, yes, sir.
Standing matter number 20.
May I please, your lordship?
Yes.
My senior colleague is on legs in court number 1, my lord.
Acha. After some time then, let her come.
Yes, yes, sir.
Item 18.
Yes, Mr. Gupta.
My lord, regarding the instruction, my lord, one student has left, my lord. I have got the information on 7th of September, my lord. Just exact date. My lord, on 7th September, one of the students out of 28 selected from Madhya Pradesh, he has withdrawn. But my lord, the contention of the authorities is that, my lord, that if any students withdraw, then the vacancy carries forward to the next year's admission. And the admission process for this batch is already closed. And my lord, my second submission is that, my lord, under the reserve category, the students who have been selected, my lord, the marks secured by the petitioner is, my lord, if we compare with the marks of the last reserve category candidate who has been selected, the marks of the petitioner is below that. So therefore, he is not in merit. And if presuming, my lord, if he is allowed to join, then multiple litigation may also happen because other students who are above the last selected reserve candidate, they will also come and say that I also ought to have been admitted. That is the difficulty.
And where is your affidavit?
For the affidavit, additional affidavit, my lord, which we have filed.
In which paragraph you have explained it?
My lord, paragraph 10, my lord, at page 58. If I may read, my lord, that it is pertinent to mention herein that the admission process for July 24 batch has already been over. It is further stated that more than half the term is already over and the admission process for the next term has already started. Entrance of the student at this stage will lead to logistic and administrative constraints. The creation of an additional vacancy owing to a withdrawal of personnel on personal grounds by one of the cadets will be filled in subsequent batches post approval of the higher authorities governing the institution.
So where is the rule?
No, that specific rule I have, my lord, asked them, my lord, there is no, they have stated that there is no specific rule.
Then?
My lord, rather they have also, my lord, asked me for some time to take instruction, my lord.
What time?
Regarding the rule, my lord, whether the contention which they have stated in paragraph
No,
10.
unless you were supported by any rule,
Yes.
how can you take such a
So that instruction I have taken, my lord, so they are saying, but they need some time to produce the instruction regarding this paragraph 10, that my lord, additional vacancy cannot be, it will be filled in subsequent batches post approval of the authorities. For 28 candidates, my lord, admission is closed. It is over as per the instruction.
No, where you have taken your stand that he is below the last reserve category candidate?
That is in affidavit in opposition, my lord. My lord, paragraph 14 at page 28 of the affidavit in opposition.
Paragraph 14.
14, my lord, of page 28 of the affidavit in opposition. I mean,
Paragraph number 14.
14, my lord. If I may read, my lord.
Hmm.
That in reply to para 14 of the writ petition, it is stated that as per the policy, only 28 candidates were to be selected for admission. And the petitioner could not qualify as he couldn't come within the scope, the cutoff marks. As per the All India Merit List for RAMC entrance examination, December 2023, for the term commencing July 24, the petitioner was at serial number 37 with 249.75 marks, whereas the last selected reserve category candidate has secured 254.25 marks. And for that reason, he could not be selected. Not only that vacancy issue, but he is also not coming within the merit zone of the.
No, at that point of time, there was no vacancy. While you have filed this affidavit.
Yes, no. No, my lord, when one student goes out, my lord, what will be the position, my lord, that depends upon the policy, my lord. The policy which they are saying that if the vacancy is created, there can be no subsequent admission. My lord, I will just take, my lord, if I may pray that, my lord, if it is listed tomorrow, my lord, I will take instruction on that. My lord, I have already asked them twice, thrice, my lord, but they are not able to clarify exactly whether there is a policy supporting, my lord, paragraph 10, which I have just read in the, my lord, additional affidavit which I have filed. My lord, may I pray that, my lord, that my lord, matter may be taken up tomorrow. If they do not give that supporting instruction, my lord, then the list can be revised. My lord, owing the withdrawal of one candidate, if the petitioner comes up in the merit, then there may be a possibility of this selection. That particular policy, if I'll just take instruction to that effect. My lord will indicate in the order also possible. The statement which we have made in paragraph 10, whether there is any my lord, policy to that effect.
Yes.
But my lord, as my learned friend has pointed out in paragraph 14 of the affidavit in opposition at page 28, my lord. My lord, I was at serial number 37. After, as I have already submitted, my lord, after completion of written and viva-voce examination. Altogether, 44 students were selected after viva-voce. And in that list, I was at 37 out of, my lord, 36 seats, as I said. And those 44 students were sent for medical examination. And only 34 has completed the medical test, my lord. That I have stated in paragraph 12 of my writ petition. Lordship may kindly turn to page 8 of my petition. Page 8 of my petition, and these 34 students has already completed. They have admitted this. Page 8 of my petition, paragraph number 13. No, paragraph number 12. Sorry, man, paragraph 12. May I read it? That the petitioner states that out of 44 candidates who completed written and viva-voce examinations, only 34 candidates could clear the medical test and became eligible for admission to the RIMC. Dehradun for the session commencing from July 2024. The petitioner, being one of the successful candidates, was expecting invitation for joining the RIMC. Well, this statement has been admitted by their affidavit. That admission lordship will find at page 28. Page 28. Hmm? Para 13. Well, there are two paragraphs 13 marked. I will read the top one. Well, as you also got it. Para 13 on the top. That para 12 of the writ petition is admitted. It is admitted that only 34 candidates cleared medical test out of 44 candidates who qualified the written examination and viva voce examination and were eligible for admission into the RIMC Dehradun. That being the position, my lord, as my learned friend has shown in para 14 of that page, 28, my lord, I stand at serial number 37. Perhaps, my lord, this was prior to conduct of that medical examination. Because as long, so far as 34 student has completed, and I have categorically stated I stand next to get the call if we agree to the 28 seats to be filled up, my lord. Now, out of the 28 seats, one has left. Earlier, my lord, when the students were called till 14th of August 2024, then also some few students did not took admission. Then another 2 students were called on 28th of August 2024. Last calling was on 28th of August 2024. That is not in my affidavit because I have filed my affidavit prior to that. But this is my instruction. On 28th of August, another 2 students called for. They took admission. Altogether 28. Thereafter, one left, which they have now admitted. One is still vacant. So, my lord, there is no any hurdle to give me and calling for admission, my lord. And in the merit list, my lord, as they said, the last cutoff mark is this. As one student has created the vacancy, so I will go up, my lord. Now the last cutoff mark is my mark. Because I will go up. Because you have prepared a list of 34 altogether who is eligible for admission in this session. Earlier you said 36 seats. Now you said 28 seats. Okay. If 28 seats students have taken admission, one has left, and by that leaving, they created one vacancy. Then the next, whoever it is, my lord, if it is, I am in the next list, I will get it, my lord. That is why, my lord, I requested let them produce those documents also, list of candidates, my lord, who has cleared and where I stand in that list. But that has not been produced. Even if, my lord, they have not denied also that position. I stand in, out of the 34, I stand at 31 position. Altogether, 30 students called, 28 took admission initially, one left there from also. Now, 28 students are there, and my position in the merit list, final merit list is at 31. I should get a calling, madam.
Here, one thing I would just like to add. I have worked out from the writ petition, which has this is the part of the writ petition, my lord. My lord, I have worked out the petition. My lord, in the writ petition, my lord, the petitioner has, my lord, stated that, my lord, 28 candidates were called. My lord will take paragraph 13. My lord, these are the candidates who were called. 18 candidates and, my lord, 10 candidates. Now, my lord, I have worked out the marks secured by, my lord, each candidate. My lord, I have by hand, I have written it, the marks. So, my lord, will see in the list of for the candidates who were called on 14/8. My lord, at serial number 7, the marks secured by the reserve candidate from Haryana is, my lord, 255.25. So, my lord, and that is the, my lord, marks, the last marks, the learned friend, my lord, was trying to say the final list of 28 candidates who were finally selected. My lord, this is the candidates who were called. And in that, if we go through the marks secured by all the candidates, my lord, the last marks of the reserve category candidates would come to 255.25 at, my lord, serial number 7, Bhumik Chauhan. But the petitioner, my lord, as a reserve category, my lord, he secured 249.75. So, unless the list is revised and he comes up in the category of reserve list, he will not be selected because of not having merit. Because last mark secured by a reserve category candidate is coming to 255.25, and the petitioner has secured 249.75. And the candidate who has withdrawn, Devans Mishra, his marks is 303. We'll see at serial number 3. Serial number 3, Madhya Pradesh. He is the candidate who has withdrawn. His marks being a reserve category candidate is 303.50. So below 303, if we see, the marks further, if we see the marks secured by the reserve category, it is the last marks comes to 255.25. So even if he goes, Devans Mishra with the reserve category, his marks is 303. Whereas the marks secured by the last reserve category candidate is coming to 255.25, and the petitioner has secured 249.75. Anyway, he is not coming in the merit. Because the marks secured by the candidate who has withdrawn, his marks was higher than the petitioner's marks. And the petitioner's marks is much below the last reserve category candidate who was selected. Finally selected.
No, in between them, is there any other candidate, reserve category candidate who was not selected?
No, these all are selected, my lord. The list which is given by the petitioner, out of these are the 28 candidates who were called. Out of this, only one candidate, Devans Mishra, he has withdrawn.
Is there any other candidate above him who was not selected for admission?
Above the, my lord, above the petitioner.
No, above him, is there any other candidate? Reserve category candidate who was not selected?
Yes, my lord, that will have to take instruction, my lord, whether, but from the marks secured, it is evident that.
No, that's all right. But
No,
my question is pointed. That
Yes.
is there any other candidate above him who had not been selected?
Because the candidates who have been selected, my lord, the last reserve category candidate marks is already, I have, my lord, in the column I have given, that is 255.25. So above that marks, no one is selected. 255.25 is the last marks of a reserve category candidate who has been selected. Anyone securing below it,
No.
below 255.
There is no benchmark. Is there any benchmark that the reserve
Yes,
category
merit,
candidate?
merit is followed, my lord. The All India merit list, my lord.
No, if above him no other candidates are there, then where is the problem of
Above him,
admitting him?
above him, my lord, these two candidates are there, my lord, which I have pointed out.
Which one?
By serial number 6 and 7. 6 and 7, my lord. In the 6 and 7, my lord, Aryan Mohanty and Bhavik Chauhan. One has secured, my lord, 255.75.
No, they were already admitted.
Yes.
Then?
So, my lord, due to withdrawal of one candidate, my lord, now there is no vacancy because all the seats are filled up. 28 vacancies were there, my lord. 28, all the vacancies.
No. On account of leaving this
Devans Mishra.
Devan Mishra.
After leaving that, my lord, the next lower marks of reserve category comes to serial number 6 and 7. And that is filled up. They are
6 and 7 already admitted.
already admitted.
Then?
Now, my lord, owing to the withdrawal of Devans Mishra, the petitioner is still not coming into the merit because he has secured.
No, maybe,
259.
but above him there is no other candidate.
No, above him, my lord, these two candidates are
No,
there.
they have already selected. They have
Therefore, my
already
lord, there
taken
is no
admission.
vacancy. Therefore, my lord, there is no vacancy now. Owing to withdrawal of one candidate, my lord, which my learned friend was saying, he secured 303 marks. Now below that, there are other reserve category candidates who have already filled up the seat. And the petitioner was even below those two reserve category candidates at serial number
Maybe, but
6 and 7.
right now there is no reserve category candidate who had not taken admission there.
In that vacant place.
Yes.
Yes, madam.
So
Yes.
then he is the person
Yes.
who
yes.
has to be admitted.
Unless, my lord, there is in the list, if there are some other who is above him.
No, you could not show the list.
No, I have to take instruction, my lord, because
What instruction?
they are not
You
giving.
show the list is available before you show me.
No, my lord, the 34.
You show the rule, who is prevented you in admitting him, and you can carry forward the vacancy to the next academic year.
That, my lord, I am praying for till tomorrow, my lord, only because.
No,
they have
tomorrow again you will come and you will submit that this academic, half of the academic period is over.
No,
We
my lord,
cannot
I
admit
will
him.
take it, my lord, tomorrow, because I am already, since he is a student, my lord, I am also taking instructions in a very short duration, my lord. We'll see 2 affidavits we have filed within a period of a week. So I am also, my lord,
No,
responding with the department.
you
My
are-
lord,
you
will
are-
give me only, because ultimately.
No, merely because you have submitted 2 affidavit in a week, it doesn't mean that you were so sincere. The required information has not been furnished to the
My
court.
lord, they are not giving me, my lord, that's why. They have asked for time.
Then we will pass the order, you follow, you face the music then.
My lord, we'll give it till tomorrow's time, my lord. I will also inform the authorities that my lord's view is this, my lord, and then it will be better, my lord.
You could not produce the rule. You could not produce the list. You were
List?
relying upon the document filed by the petitioner.
No, list.
How you were sincere? What
All the
extent
list
you
I
were
have
sincere?
produced, my lord. All the list I have produced. All the lists are there, my lord. All the lists I have produced, my lord.
Okay, I'll list the matter tomorrow.
Tomorrow.
Heard?
My lord, may I pray, my lord, it will be on the top of the list, my lord. Tomorrow is the last day, my lord. Again, that same. thing will
Last day, but unfortunately, tomorrow I will not sit.
Lord, let it be at 2, my lord. Let him take instruction. Because, my lord, I have one submission, my lord. I have already made this categorical statement in my affidavit in reply, as page 41 of mine, that I am the next person to be appointed and to be admitted. That has not been denied while filing the second.
That I will clarify.
That have not, my
That
lord.
I will clarify
No,
tomorrow.
my lord. Every time, my lord, they will take time and end of
Otherwise,
the
my
day, they
lord,
will say that.
otherwise seats are full. My contention is, my lord, he will be in a reserve category.
And finally, my lord, time will kill me,
He
my
is
lord.
not in the merit. Otherwise.
Those classes are going on. Last to calling was on 28th of August. September middle to my instruction, my lord, classes have already been started.
All the seats
In
have been
page 41, lordship may kindly see, this has, and there is nothing to be taken instruction, my lord. I may read, my lord, page 41 of my affidavit in opposition, reply. I have categorically stated. This was my submission on last occasion also, my lord. On the second paragraph in that page, that the deponent states that he has learned from reliable sources that although 28 students were called for taking admission, but some students did not take admission or left the RINC after taking admission, and therefore another 2 students, that is student up to serial number 30 of the merit list, were called for taking admission. The deponent has come to know that at present, altogether 28 students have been pursuing their course in July 2024 session of RIMC. The deponent therefore humbly prays that before this honorable court to direct them to produce the final merit list of the student boys who have completed all 3 rounds of examination for admission in RIMC. This includes the medical also. The list of students who were called for taking admission for July 24 session, and list of students who are presently continuing in their course till July 2024 sessions. To this, they have not replied anything.
That list is
I stand
already
that-
there, paragraph 13, my
No.
lord, that list is the list.
That is the list prior to
15 plus
medical.
10.
No, that is prior to medical. That is prior to medical. And I stand at serial number 31, you have called up to 30. Well, next is my calling. They have not denied this. They have not denied this. They had the opportunity to while filing the second writ petition. Sorry, my lord, second affidavit in opposition.
Yes, you produce the rule
My lord,
by 2 p.m.
By 2, my lord.
2 p.m., my lord.
It's
It will be difficult, my lord. It will be difficult. My lord will take it tomorrow. Yeah, also the authorities, my lord, they have to take approvals also.
No, my lord, originally it was fixed at 2, my lord, in the morning today. Well, again, it will go back and time will finally, my lord, this boy will be killed by time only. We are having 20 days vacation. My lord. Lordship will dispose it of with a direction also, my lord, if I stand the next at 31 position. This
Okay,
next is my
Mr.
number.
Gupta,
in the-
you try to find it out at 2 p.m.
2 p.m.
I told my lord, this is to be finished, my lord, otherwise time will kill him, my lord. I'm obliged.
Item 20, time being.
It's very sorry, let's before the code number 1.
Okay, no problem.
Lordship, I have spoke with the respondent, Lordship. Make him understand the situation also. He also stated that, Lordship, we have filed our affidavit showing the financial status also. Current salary is near about 60, Lordship, but he has one housing loan, 15,000 per month. It is deducted from his salary. Plus, he has now 2 minor debtors.
It was in force till December 2003. So the crux of the Malad principle is that if the process has started in the year
Prior to coming into force of the new pension scheme,
benefit
then
of
they
the-
will be covered by the earlier pension scheme.
Here in this case, what has what has happened in this case, 96 advertisement was. Somehow, my lord, they have not published the select list of the in respect of the Morigaon district. So we came before the court. Court has passed this order, page 47. I'm just noting it down, my lord. Page 47. It starts from page 34. Here, page 46, then relevant is, may I just read this one? Hard so and so, papers sent to the petition, an affidavit has been filed in the present case, but the affidavit in so position filed by the state in similar other cases, it has been admitted that a selection list was prepared by the competent authority, and it was for the high powered committee for approval. Till date, no approval has been communicated. A division bench of this court in so and so held that the validity clause would come into operation only after the director accords approval. Thereafter, the division bench of this court in the said directed the authority to consider and accord approval of the list prepared. Similarly, is the position in the instant case, and this petition is disposed of with a direction to the respondents 1 and 2, the Secretary, Government of Assam Education Department and the Director of Secondary Education to consider and pass appropriate orders for approval of the list. The respondent shall dispose of the matter in terms of the direction within a period of 1 month from the date when the order or copy of this order is furnished to them. Until the matter is considered and disposed of by the respondent, no post of assistant of high school in the district of Morigaon shall be filled up by any person outside the select list prepared by the district level selection board in the month of March 2001. So this was an order in the month of 4th, 10th, 2002. They did not do anything. We came before the court and then filed a contempt case. Contempt case, page 4850. They passed an speaking order. Speaking order, your lordship will get it at page 48. The court has directed to pass order on the basis of the select list. But what speaking order they have passed, your lordship can see page 50. It starts from page 48. page 50. Second paragraph. It is evident from the WT message dated so and so that the validity of the select list has gone. So therefore, respectively, which dealt with the assistant teachers and subject teachers respectively, according to the stipulations of the government order dated so and so, the select list of Morigao districts from which the petitioner's claims appointment stood expired with effect from 31/3/2001. Though no teachers were appointed in the Morigao district within the validity period of the select list, government cannot now act upon such select list. So this is the stand taken by them. Contrary to the order passed by the, in total violation of the order passed by the this honorable court earlier, as I have reflected on them. Now we came and we challenged this order. Challenged this order, and your lordship will get it at page 51. This was the order passed. (64), paragraph 12. We had to challenge the speaking order passed by them. So relevant is paragraph 12, page 64. For the reasons discussed herein above, I have no hesitation to hold that the impugn order is discriminatory, arbitrary, and designed to frustrate the implementation order passed by this court. And as such, the same is liable to be quashed. Accordingly, the impugn order dated 4/10/2002 is hereby quashed as not sustainable in law. In the result, the respondents are directed to implement the earlier order of this court dated 2002 by publishing the select list prepared by the district level selection board in the month of 2001. Within a period of 2 months from the date of receipt of this certified copy of the order, and those who are found successful in the select list be accorded appointment strictly in order of merit against the vacancy available at the relevant point of time within a period of 1 month. So this was the order. So now they have passed this order, appointment orders they have issued in the month of on 15/2/2011. That your lordship may come at page 66. Page 66. In compliance with the Honorable Guwahati High Court's order dated so and so, the appointments have been passed. Now page 67. Now they have taken an undertaking. As your lordship got it. Page 67, last paragraph. Second paragraph. The appointee concerned will have to furnish an undertaking at the time of joining in the school as prescribed by the finance department regarding introductions of the new pension rules, along with joining report to the heads of the institutions concerned, which reads as follows. I understand and accept the government servants joining in the service on the state of Assam on or after 2005 shall not be governed by the existing Assam rules 2000 Assam service pension rules 1969 and orders issued thereunder from time to time, that the pension and other retirement benefits will be governed by a set of new pension rules. So on the basis of this undertaking, they are saying now you'll be governed by the new pension schemes, and all other persons who have been appointed pursuant to the advertisement dated 28/12/96, they are getting their old benefit of the old pension scheme. Now government has said because of the change of rules, you will not get the benefit of the new pension scheme. You will get the benefit of new pension schemes. So this is the factual position. So we came before this court, my lord, at page 96, your lordship will get in my lord, in one of the NF railway case, I'm just pointing out on page 88.
Page number
88. Your lordship will just kindly note.
Annexure 7.
Annexure, yes. And there was one time, this was issued in the year 2020, one time option to switch over to old pension schemes under pension rules 1993 from NPS of those railway employees whose selection for appointment was finalized before 1/1/2004.
No, that was in case of central government.
Yes, and I'm just pointing out, so this kind of measures are taken in respect of the central government because of the various judgments passed by the
No,
court.
now,
Now,
because of the judgment of division bench of this
Yes.
court,
Yes.
the law is settled
settled,
and that has not been set aside.
not been settled.
Then, Mr. Borpuzari,
Now, yes.
what is
Now,
your
the
stand?
on this undertaking, my lord, I would like to just give two judgments.
Yes.
Undertaking, my lord, the higher authority, they cannot force somebody that you, at the time of giving employment, they have taken an undertaking that you will be governed by that. That cannot be done. My lord, I am giving a full bench judgment of the Madhya Pradesh High Court and the 2024 live law, your lordship has got it, my lord. There, your lordship will get paragraph 20. Give me paragraph. Live law. Paragraph 30, my lord. Paragraph 20 and 30, 28 and 30. Employee has no option but to give an undertaking so as to avail the benefit of pay fixation. Undertaking cannot be made.
Paragraph number
30.
of the Madhya Pradesh judgment.
Yes, full bench judgment.
Yes. The division bench of this court.
Effect of undertaking, as a higher authority, you cannot ask the lower authority that no. The division bench of this court in case number so and so held that since an employee had no option but to give an undertaking so as to avail the benefit of pay fixation, it cannot be said to be a voluntary act. Therefore, such an undertaking cannot be made the basis of sustaining the recovery. The effect of the judgment is, my lord,
No, that was based on primarily in a Belmar Lowry case.
yes, that case is, my lord,
So let us come to the Supreme
Yes.
Court judgment.
2013 8 SCC 345, para 30 will do it.
Relevant paragraph
30.
30.
Lord, you buy force, my lord, if you cannot take undertaking and my lord, you cannot force a person to waive the benefit which he is entitled to get under a provision of law. So
Well, let us read this paragraph.
Yes, 30. Where the actions of an employer bear public character and contain an element of public interest as regards the offers made by him, including the terms and conditions mentioned in an appropriate table, which invite the public to enter into contract. Such a matter does not relegate to a pure and simple private law dispute without the insignia of any public element whatsoever. Where an unfair and untenable or an irrational clause in a contract is also unjust, the same is amenable to judicial review. The Constitution provides for achieving social and economic justice. Article 14 of the Constitution guarantees to all persons equality before the law and equal protections of law. Thus, it is necessary to strike down an unfair and unreasonable contract or an unfair or unreasonable clause in a contract that has been entered into by the parties who do not enjoy equal bargaining power and are hence hit by Section 23 of the Contract Act, and where such a conditions or provisions becomes unconsignable, unfair, unreasonable, and further is against public policy, where inequality of bargaining power is the result of great disparity between the economic strengths of the contracting parties. The aforesaid principle would automatically apply for the reason that freedom of contract must be founded on the basis of equality of bargaining power between such contracting parties, and even though an ad idem is assumed, applicability of standard form of contract is the rule. Consent or consensus ad idem as regards the weaker party may therefore be entirely absent. Thus, the existence of equal bargaining power between the parties becomes largely an illusion. The state itself or a state instrumentalities cannot impose unconditional conditions in a statutory rules regulation vis-a-vis its employees in order to terminate the services of its permanent employees in accordance with such terms and conditions. Here in this case, what has happened, madam? Here, board directed you say you publish the select list within a particular time in the year 2001. They did not publish. They ultimately issued an appointment order on the basis of an order passed by this court in a contempt order passed by this court, and ultimately they said no. Now you take an undertaking that your old pension scheme will not be applicable. You will be governed by the new pension scheme. What they do not have any choice. They persons who got selected in the year 2000 on the basis of the advertisement in the year 1996, they are getting employment in the year 2011, and they are forcing them. You give an undertaking. Do they have any choice? They do not have any choice. So they have to accept the undertaking. Now they are saying, government is saying, my lord, since you have given undertaking, you will not be given the benefit of the old pension schemes. So that they cannot be forced to do so. That is what the Balmer says. That is what the Madhya Pradesh Court says, and that is many other Supreme Court judgment also says. So therefore, my lord,
No, whether this judgment specifically dealt with the issue before this court now.
no, not this court only on the basis of the undertaking, because they are going to say at the
No,
time
here
of
the condition is that it should be unconstitutional.
yes, unconstitutional.
How?
The undertaking obtained, my lord, from the employer, from the employee, it is unconstitutional because against the law. There cannot be an
No,
undertaking.
can
from
it
an-
be said that at the relevant time already this new pension scheme come into force?
Force. So no.
So what wrong with the
Law is, my lord,
government
when-
and
what was prevailed during at the time of an advertisement, you cannot deny the benefit of that what was prevailing at that point of time by by taking some writing. So that will be against the law. So this is what, just because, my lord, now that advertisement was issued in the year 1996, now they are, because of the law established by this court, that when process initiated prior to the commencement of the new pension scheme, that so therefore they are entitled to get the benefit. Now they are saying, no, you cannot get the benefit because we have taken an undertaking to form them. The first order they have violated. So first they are saying no. The validity of the list is gone. First order is that, my lord, validity of the list gone. So we challenge that order. So now court says, no, you pass the order, but after about a year or so, after about 3 years, 2009 order was there.
No, that's all right. There is a lapse on their part.
Yes, so
but
that undertaking will not, that undertaking, my submission is that undertaking will not annul my right, or it will not debar me from what is due in as per provision of law.
Achha.
So that is not. So therefore, my lord, I would submit, my lord, in view of the division bench judgment and taking into consideration the date of advertisement and the persons who were appointed.
No, Mr. Das, my question remain unanswered. My question is, can we say that this condition is unconstitutional?
That undertaking?
Yes.
Because if the undertaking takes my right, my lord, away, and it treats me dissimilarly, similar to the persons who were appointed like me, it is unconstitutional. This is what the Balmer also says. Now
That's Article 14.
Yes, and it is arbitrary because persons who were selected and appointed like me, they are getting the benefit of old pension schemes. Now, just because they delayed the appointment, it will not deprive me
from getting the benefit.
Yeah, my right of, my lord, service benefit. So that they cannot do. Now they are harping on this undertaking, but in the affidavit, they do not say anything about undertaking. In the
Acha.
affidavit, they say the finance rules has been changed, and the new that NPS has been brought in. So therefore, why not, we cannot give this. So there, my lord, besides all these two judgments, government has also taken a minutes. The government of Assam will consider extending the benefit of old pension scheme to those employees who joined us government service after 2005, but the recruitment process for the concerned post was started prior to January 2005. That government also now admit, this is the minutes they have taken on 15/3/2024. So but
15/3/2024.
24, 120. Where?
No, if that is the stand of the government,
That is the now stand of the government.
then
But
this
I'm not on the minutes, I'm claiming my right on the basis of the division bench judgment. Your lordship will issue a direction for giving the benefit.
no, that's why my question is, if the government has already taken a stand
Yes.
that if the recruitment process is started prior to coming into force of the new pension scheme,
Yes.
by virtue of these minutes, where is your case now?
No. This is a minutes are produced in the year issued in the year 2024.
Yes.
But here in this case, since they have been denied, so they have been denied, your lordship.
No,
will have to
by
interpret-
virtue of these minutes now, you are also entitled to.
No, that's a different way. When government is going to decide, we do not know. This is only a minutes. No order has been issued to that effect. I'm just pointing out these minutes only for the purpose of your lordship's knowledge. That this is the stand taken by the government. Now I am on this impugn order at page 127. Page 127. The impugn order has to be set aside and the direction has to go from the state.
Impugn order is at page number
127.
Yes. Okay.
Yes, it says so. After careful, page 129, after careful consideration of the above and all other aspects, the government in the department has decided that the claim of the petitioner for allowing them to avail benefit of the Assam, that's the pension rules to 1969 instead of the new NPS cannot be considered as they join in their respective schools after 2005. This impugn order has been passed pursuant to order passed by this court. Your lordship will get it at page 127.
Okay.
So this has to be set aside. Okay. On the basis of the division bench judgment. Direct them to provide the benefit of old pension schemes immediately. In that case, they will have to surrender whatever the pension they are getting. And now whatever the benefit they are given to the employee, they will have to surrender that benefit.
No, they are still serving.
They are still serving. One or two return.
So where is the question of returning?
No, sorry, madam, I'm not there. No.
Yes,
Change
Mr.
of-
Barbuzari.
Take some time, lordship, maybe.
Take some time.
Whether.
Then at 2 p.m.
2 p.m.
Okay.
Obliging.
I'm obliging.
Yes.
Yeah, please, your lordship. Here, my lord, I am representing the respondent number 3, that is the Commissioner and Secretary, Finance Department. Now, if we come to the prayer portion at the writ petition, my lord, at page 27, we will find, my lord, that the petitioner has challenged, my lord, the order dated
27/7/2023 passed by the respondent number 1. That is, my lord, the secretary to the government of Assam School Education. And that order is annexed at Annexure 12. That is the speaking order. If Lordship may be pleased to allow me to quickly read that speaking order. Let us see what the speaking order is all about. Lordship may kindly come to page 127. Because apart from the speaking orders, the petitioner has not challenged, specifically challenged, my lord, the insertion, or as we say, my lord, the imposition of the condition, which learned senior college has, my lord, sometime before drawn my lord's attention to that particular clause that an undertaking was given by the petitioners. Before that, Lordship may kindly see the speaking order at page 127. Which Lordship's
But Mr. Borposari, this court can mold the relief being sought for by the petitioner also.
So that aspect of the matter is always open, but whether under the facts and circumstances of the present case, and I will be drawing my lord's attention to the relevant provisions of law, whether after that this honorable court would be pleased to mold the relief or not. I am just laying a foundation of my submission. My lord, therefore, I am drawing lordship's attention to that, my lord, impugned order. That is the speaking order at page 127. I am reading it, my lord. Is an order, my lord, read the order dated 3/11/21 passed by the Honorable High Court in WPC number so-and-so, Dugal Kishore Chaudhary. Dugal Kishore Chaudhary is the petitioner number 1 in the present writ petition also. Also, the detailed report from so-and-so read the representation submitted by the petitioners. Now, the findings. It appears that in pursuant to an advertisement dated 28/12/1996, issued by the Director of Secondary Education, Assam, for filling up of 1,000 numbers of vacant posts of graduate teachers in various high schools and high madrasa schools of the state. The petitioners participated in the selection process under Morigaon district. Although they were selected in the year 2001, they were not appointed at that time, as the select list in respect of Morigaon district already expired on 31/3/2001. So will kindly mark this. The select list has already expired on 31/3/2001. This is a finding of fact. This is a finding of fact.
Yes.
I'm continuing, my lord. As such, the petitioners approached the Honorable High Court, and in pursuant to certain orders of the Honorable Court, they were appointed on 15/2/2011 as graduate teachers in different higher secondary schools under Morigaon district. At the time of their joining, as per instruction contained in their appointment orders, they have submitted an undertaking that they shall not be governed by the existing Assam Service Pension Laws 1969 and orders issued thereunder from time to time, and that their pension and other retirement benefits will be governed by a set of new pension rules which are being introduced in the line with the contributing pension of Government of India. But while representation dated 23/12/2020, the petitioners are claiming that they are entitled to the benefits of pension as per the Assam Services Pension Rule 1969 instead of the new defined contribution pension scheme on the ground that all who were selected and appointed in pursuant to the same advertisement dated 28/12/1996 in other districts have been allowed to avail pensionary benefits as per Assam Services Pension Law 1969. They also approached the Honorable High Court by filing writ petition by number 5817 so-and-so, seeking an instruction on their claim, and the Honorable Court by its order dated 3/11/21 disposed of the case, directing the Principal Secretary to the Government of Assam Secondary Education Department to decide the issue, as well as to pass a reasoned order in the representation of the petitioner in consultation with the Finance Department. Lordship will also mark this, because the leeway has been given by this Honorable Court to the government to decide the claim of the petitioner, meaning thereby this Honorable Court in the earlier round of all the litigations had not decided upon
their rights with regard to whether they will be covered under the new pension scheme or the old pension scheme. That right was not decided, but it was left open to be decided by the government. Now, what was the decision? As per Honorable High Court said direction, the matter was endorsed to Finance EC3 Department for their views. But the Finance Department advised the Department of School Education to take up the matter with ART and PPG Department, since the matter is relating to admissibility of pension under Assam Service Pension Rule 1969 or new pension scheme. Then the matter was also consulted with the ART and PPG Department, that is, my lord, the Pension and Public Defense Department. And they advised the department to examine the matter as per guidelines issued by the Finance Budget Department, file number so-and-so dated 6/10/2009, and to consult the Finance Budget Department on the matter. Now, this, my lord, 6/10/2009 is the office memorandum which we have annexed in our affidavit that is pertaining to, my lord, introduction and promulgation of the new pension scheme. Accordingly, on perusal of the above mentioned guidelines issued by the Finance Budget Department, it appears that all new entrants joining state government services on regular basis against vacant sanction posts on or after 1/2/2005, including the teaching and non-teaching employees of provincialized educational institutions of the state, shall come under the purview of the new defined contribution pension scheme. It also appears that the Assam Services Pension Rules 1969 and amendment made from time to time thereon will not be applicable to the government servants who were joined on or after 1st February 2005. Then the order. After careful consideration of the above and all other aspects, the government in the Department of School Education has decided the claim of the petitioners for allowing them to avail pensionary benefits as per the Assam Pension Service Rule 1959 instead of the new defined contribution pension scheme cannot be considered, as they joined their respective schools after 1st February 2005. This is issued in compliance of Honorable High Court's order so and so. Now, the primary thing that emerges, my lord, from this speaking order is that the petitioners hearing were appointed after 1/2/2005, which is the cutoff date for, my lord, bringing into effect the new pension scheme. Now, let us, my lord, come to the appointment orders issued to the petitioners. Lordship may kindly come to, my lord, page 68. This is the appointment order issued to the petitioner number 1. I'm reading it, my lord. In compliance of Honorable Guwahati High Court judgment order passed in so-and-so, dated so-and-so, and passed in WPC so-and-so, so-and-so, and subject, and in pursuance of government orders dated so-and-so, and subject to discharge without notice and without assigning any reason thereof, and subject to satisfactory police verification report and production of medical fitness certificate, and in the interest of public service, Sri Jugal Kishore Chaudhary, BA. Jugal Kishore Chaudhary is P1, petitioner number 1 in the present proceeding. The selected candidate by DEO Morigaon is hereby appointed as graduate teacher against existing vacant post, vice so-and-so in the scale of pay so-and-so, and other allowances with effect from the date of joining. This had the approval of Finance SIU Department and communicated so-and-so. Then the next paragraph, the appointee concerned will have to furnish an undertaking at the time of joining in the school as prescribed by the Finance Budget Department in their letter number so-and-so regarding introduction of new pension rules, along with joining report to the heads of the so-and-so. Now, this is the undertaking. It is given in inverted comma. I understand and accept the government servants joining the service of state government on or after 1/2/2005 shall not be governed by the existing Assam Services Pension Rule 1969 and orders issued thereunder from time to time, and that there the petition, pension and other retirement benefits will be governed by a set of new pension rules which are being introduced in the line of contributory pension scheme of the government of India. Now, this appointment order was issued, my lord, on 15/2/2011. Lordship can kindly mark it, my because the petitioners have annexed all the appointment orders. This is one of such appointment orders pertaining to petitioner number 1. And all the appointment orders, my lord, are of similar nature. Then Lordship has seen, my lord, the speaking order that has been passed by the Department of School Education. Now, what is the genesis of passing that speaking order? It is an order passed by this honorable court in a writ proceeding. Let us see that order, my lord. That order, Lordship will find, my lord.
96.
Yes, my lord, page 96. It starts from, my lord, page 96. This is the earlier round of litigation. This writ petition was instituted in the year 2021. Order that has been passed starts from page 100. May I read it, my lord?
Yes.
Quickly. Had Mr. So-and-so, learned senior counsel also had so-and-so. All the petitioners, paragraph 2 onwards, all the petitioners here participated in a selection process pursuant to an advertisement dated 20th-12-1996 for filling up of 1,000 numbers of vacant posts of graduate teachers in various high schools and high madrasa schools, and 200 numbers of vacant posts of subject teachers of various higher secondary schools of Assam. Although the petitioners were selected in the year 2001, they were appointed on 15 to 2011 in their respective posts pursuant to certain orders of the court. In the circumstances, the petitioner claimed that they ought not to be brought under the new defined pension scheme, which has its effect for all such appointments made after 1/2/2005. The petitioners have submitted a representation dated 23/12/2020 before the Commissioner and Secretary to the Government of Assam in the Secondary Education Department, Director of Secondary Education Assam, Commissioner and Secretary to the Government of Assam in the Finance Department, as well as Inspector of Schools Morigaon, claiming that in the facts and circumstances of the case, as indicated above, they ought to be covered by the Assam Services Pension Rules 1969, as it stood prior to its amendment, and not by the new defined pension scheme, which has come into effect on 1/2/2005. As it is a contentious issue as to whether the petitioners in the present circumstances would be covered by the new defined pension scheme or would be covered by the earlier pension scheme, we deem it appropriate for the Commissioner and Secretary to the Government of Assam in the Secondary Education Department to decide the issue, as well as to pass a reasoned order in the representation of the petitioner. As the applicability of the new pension scheme is also within the purview of the Finance Department, the Commissioner and Secretary in the Government of Assam, in passing the reasoned order, shall also consult and take the views of the Finance Department and accordingly incorporate the views of the Finance Department in the reasoned order to be passed. It is stated that presently there is no Commissioner and Secretary to the Government of Assam in the so-and-so, and the responsibility are being carried out by the Principal Secretary. Accordingly, the requirement of passing the reasoned order can be done by the Principal Secretary, and it to be done within a period of 4 months from the date of receipt of certified copy of the order. If the petitioner desires to raise any further issue, liberty remains with the petitioner to file a supplementary representation on such ground. Taken in the supplementary representation can also be taken into consideration while passing a reasoned order. As agreed by the parties, a copy of the writ petition be also provided to the Principal Secretary to the Government of Assam in the Secondary Education Department along with the certified copy of the order. Now, my lord, my respectful submission is a bare perusal of this order would go to show that they have contended before filing of this representation, this writ petition, in the earlier round of litigation, they had claimed that, my lord, they ought to be brought under the purview of the old pension rules, 1969 rules, and not under the purview of the new pension scheme. It is not known from this order whether they have challenged that condition, which, my lord, has been harped upon by the petitioners, the condition that is the undertaking, which they say that they do not have the bargaining capacity, and they had no choice but to abide by the condition that was imposed by the state. whether the imposition of such a condition was put to challenge by the petitioner at any point of time is not known. Number one. Number two, even in the present writ petition, there is no challenge in particular to such condition. Now, from this order passed by this honorable court in the earlier round of litigation, what emerges is that the court has not taken any decision. Court has not issued any direction.
No, Mr. Borpozari, at that time, one representation was pending before the authorities.
Therefore,
That was not decided.
Therefore,
Ah.
therefore, now, since my lord, that representation has been decided,
Hmm.
and I have drawn my lord's attention to the speaking order,
Hmm.
and the speaking order clearly states, my lord, that since they were appointed after 1/2/2005, they will be covered under the new pension scheme and not under the old pension rules. Now, let us see, my lord, that appointment order, once again, if we see that appointment order at page 68, which lordship has just now seen, my lord, it emerges from the appointment order that this is not a case of regularization. This is a case of fresh appointment. Now, if it is a case of fresh appointment, then, my lord, if it is after 1/2/2005, then under the law, I will be drawing my lord's attention to my affidavit. Under the law, my lord, under the provisions of the Assam Pension Rules 1969 itself, it says, my lord, that if a person is regularized or appointed after 1/2/2005, then he will be covered under the new pension scheme and not under the old pension. Then, lordship may kindly come, my lord, to the affidavit filed by the finance department. My lord, that affidavit starts, my lord, from running phase 134, my lord.
Yes.
If lordship may be pleased to take up page 135, I may read from paragraph 4 onwards of that affidavit. Paragraph 4, the answering deponent begs to state that the finance budget department, by its letter number so-and-so dated 25/1/2005, informed all the additional chief secretaries, principal secretaries, deputy commissioners, and head of departments of government of Assam about introduction of the new pension scheme and making it mandatory that all fresh recruitees joining the service of the state government on or after 1st February 2005 shall have to furnish an undertaking along with the joining report as prescribed herein below. Now, this is the undertaking which lordship finds at page 136. This is precisely the undertaking which is also seen, my lord, in the appointment letter. Yes. Subsequently, in pursuant to cabinet approval dated 4/9/2009, Finance Budget Department by number so-and-so and dated 6 October 2009, issued one office memorandum introducing the new defined contribution pension scheme, making it applicable to all new entrants joining the state government services on regular basis against vacant sanctioned posts on or after 1/2/2005. Then, my lord, in view of the introduction of the new defined contribution pension scheme 2009 and in pursuance of the approval of the cabinet held on 5/7/2011, the Pension and Public Grievances Department, Government of Assam, in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India, issued a notification number so-and-so dated 13/14 July 2011, amending the Assam Services Pension Rules 1969, inserting a new rule, that is Rule 2A. Lordship may kindly mark this. Insertion of new Rule 2A. In the principal rules, after Rule 2, the following new Rule 2A shall be inserted, namely 2A. Provisions of this rule shall not apply to government servants appointed on or after 1/2/2005 to the services and posts in connection with the affairs of the state government of Assam, which are born on pensionable establishment, whether temporary or permanent. such employees shall be governed by the new defined contribution scheme 2009, newly introduced by the government of Assam. In the aforesaid notification dated so and so, it was made clear that the new amendment shall be deemed to have come into force with effect from 1 to 2005. In pursuance of the approval of the cabinet held on 5/7/2011, the Pension Public Grievances Department, in exercise of the power conferred under Provision 309 of the Constitution of India, issued another notification amending the General Provident Fund Rules 1937. Now, General Provident Fund Rules have also been amended. Then, my lord, we have stated the entire background of how this new pension scheme came into existence and what are the consequences of the new pension scheme. Lordship will kindly mark here that the new pension scheme was brought into effect as a consequence of a decision taken by the cabinet. That is the highest
No,
body.
that's all right. There is no dispute about it.
Yes.
No, you come to the division bench order of this court.
Division bench, I will be coming. Before that, Lordship will kindly see, my lord. Kindly see, my lord. Lordship may kindly come to page 159. Page 159 of that affidavit.
Yes.
My lord, that is the cabinet approval. That is the cabinet approval, my lord, with regard to, my lord, bringing into effect of the, my lord, new pension scheme. And thereafter, Lordship, at page 160, Lordship will see, my lord, the rule. This is amendment to Rule 2A. Now, by virtue of this amendment made in the Assam Services Pension Rules 1969, it has been categorically, my lord, provided that those persons who are appointed, my lord, in connection to services and posts, in connection with the affairs of the state governments, my lord, such employees will be governed by the new defined contribution pension scheme and not under the 1969 rules. They are claiming their benefits under the 1969 rules. 1969 rules, after amendment, itself says that those employees who are inducted into service of the government after 1/2/2005 shall not be covered under the 1969 rules, but they will be covered under the new defined contribution pension scheme. This, in my respectful submission, is a statutory mandate. The statute.
No, that's all right.
Yes.
That has not been disputed by the petitioners.
So therefore, that division bench judgment will not come in the aid of the petitioners, because since in the division bench decision, my lord, this rule was not discussed. In my respectful submission, in view of
No. The question is, have you challenged that division bench judgment?
division
It
bench,
is still holding the field.
no, division bench judgment, my lord, is not to be challenged by us because the division bench judgment has arisen out of an order passed with regard to, my lord, services and affairs of the central government. Kindly see, my lord, I am coming to the division bench decision. That lordship will find at page 108, Sanjay Kumar. It starts from 108. If lordship is page 108, lordship will find that the respondents are Union of India, Central Board of Indirect Taxes, Chief Commissioner Indirect Taxes, Commissioner Director. And this order, the division bench order, has arisen out of an order passed by the Central Administrative Tribunal.
No, maybe, but the proposition of law laid down therein, whether it will be applicable in the case in hand or not, that is the question before that.
Yes, in my respectful submission, the proposition laid down in the division bench decision will not be applicable in the present case because since there was no finding in the division bench decision to the extent that under the rules, because they were now to be covered under the CCS rules. Now, whether perimeteria provisions in the CCS rules were amended or not, Here in our case, we have the Assam Services Pension Rule 1969. In the division bench decision, it was the CCS pension rules. Now, these rules are almost alike. But in case of Assam, there is an amendment. In case of CCS pension rules, there may not be an amendment. So since there was no amendment, there was no embargo created by the statute itself. So therefore, the division bench had given a fair benefit to the my lord writ petitioners. And that division bench decision is applicable to central government employees and services and affairs under the Union of India. Therefore, Lordship may be pleased to come to page 126. That is the direction issued by the division bench. Paragraph 26. I am reading paragraph 26. The respondents, may I read it, my lord?
Yes, yes.
The respondent authorities are directed to pass appropriate orders granting the benefit of the old pension scheme to the petitioners, as have been done in the case of other requirements initiated in the year 2003. In respect of other departments, Lordship will kindly mark this. In respect of other departments like the BSF, SSB, ITBP, etc., by the government of India. It is not by the state of Assam.
Achha.
It is not by the state of Assam. So in my respectful submission, with all humility, my lord, this division bench decision is not applicable to the facts and circumstances of the present case, since the embargo that is created under the statute by amendment of the pension rules itself was not an issue raised before the division bench, to the extent that, look, in the CCS pension rules also, an amendment was made and embargo was created. So therefore, you will not be entitled to the benefit under the CCS pension rules. Rather, you will be entitled to the benefit under the new defined contribution pension scheme. This was not the argument. This was not the argument of the Union of India, rather to say the respondents in that particular writ petition. So therefore, the Honorable Division Bench did not have any occasion to consider whether any amendment or whether any embargo has been created by the statute itself. On the basis of which statute the petitioners are claiming benefit. In the division bench decision, the petitioners were claiming benefits. Their contention was that look, we are to be covered under the CCS pension rules and not under the new defined contribution pension scheme. Division bench, after elaborating upon detailed elaboration on the various aspects of the matter, came to this finding that no, it negated the argument of the respondents and rather, my lord, accepted the arguments of the petitioners to the extent that, look, since their appointments were initiated prior to coming into effect of the new defined pension scheme, so there is a continuity. So therefore, they will have to be given the benefit. There is no way of escaping from it. So there is no embargo. There is not a single finding in the division bench decision which Lordship will find that the division bench have discussed anything about any embargo created under the CCS pension rules itself.
No, that's all right. But you see, the process is started long back in the year 19.
Maybe.
96.
Maybe.
96.
Absolutely, maybe. Maybe. But The statute now differs.
No, that proposition of law laid down in the division bench that
Yes.
if the process is started
Yes.
before coming into force of the new scheme.
And the
Yes.
vacancy also.
Vacancy, yes.
Yeah.
Vacancy also
Yes,
96.
yes. On facts, nothing is disputed. I am on pure question of law.
Mm,
Nothing is disputed on facts.
mm,
But there, it was not the case before the division bench
mm,
that the CCS, in the CCS pension rule itself, there was an embargo.
mm,
So there was no obstacle. There was no obstacle under the law created by any statute. So the division bench has traveled freely.
mm.
Here in this case, the obstacle has been created by the statute.
Mm,
Can we apply the division bench decision to the facts and circumstances of the present case?
mm,
In my respectful submission, this will not come in aid of the petitioners because they will have to challenge that rule 2A,
mm,
which have not been put to challenge.
mm.
They will have to challenge rule 2A. The legislature has put an embargo, whereas in the division bench decision, it was not the finding of the honorable division bench of this honorable court that the legislature, or for that matter, the parliament has created any embargo.
Mm,
But here, the legislature has, of the state of Assam, has created an embargo. That if you are appointed after 1/2/2005, you will be covered under the new pension scheme. If you can show that you were appointed prior to 1/2/2005, then of course you will remain under the old pension rules. That is the 1969 rules. So this is the distinguishing factor between that matter and the case in hand before this honorable court.
mm,
This is my respectful submission.
mm,
How can they overcome from the statutory embargo?
mm.
The embargo is not created by any minor department of the government of Assam. It's a creation of statute. That statute itself says.
No, but tell me, who is responsible for their delayed appointment?
But
Had they been appointed immediately after initiation of the process, along with other candidates,
yes,
then definitely they would have get the benefit without any rider.
yes, yes. But to that extent, my lord,
Now, you being responsible for the delay, now you are trying to deprive them of their rightful claim.
now, my lord, whether who is responsible for delay, this is not the list before this honorable court.
No, may not be,
Yes.
but it is associated with this list.
Yes,
Mm,
maybe, my lord.
mm,
But then, my lord, they were appointed at a later date. They
mm,
were not appointed, my lord, in the
mm,
possibly in the year 1996, or for that matter,
Mm.
within 1 or 2 years thereafter.
mm,
That, my lord, is is issue of fact, the
mm,
question of fact.
mm,
Now, they having accepted their appointments, which
mm,
were made in the year 2011, we are in the year now 2024. They were appointed.
mm,
So they have not challenged their appointment orders. It is not their case that no, I want further benefits.
mm,
If I ought to have been, why pension them? Then I am putting a question to myself, why pension? I could have asked for salaries, they give me regular pay scale from that point of time. Why
Mm.
pension? That
mm,
may be also the case. They have their right. That right is always open to them,
mm,
but they have chosen only to harp upon the pension,
mm,
taking a coup from the undertaking.
mm,
Meaning thereby, my lord, it's a very tricky argument, my lord, I must appreciate.
mm.
They have harped upon that undertaking and saying that this is unconstitutional, so therefore give us all pension.
Definitely, if we consider the same in their counterpart appointed at that point of time. Because those candidates who were appointed earlier in point of time, they are getting the benefit of new old pension scheme, and they are getting new pension scheme for no fault of them.
Precisely, my lord, maybe I may be mistaken, my lord, I do not find any such convincing material in the present read proceeding.
Read proceeding.
Yes, to show that Mr. XYZ who are similarly situated persons.
No, but Mr. Das has argued.
Good, my lord, with all respect, my lord. He has argued, definitely, with all respect. But we are before a court
No,
of.
when the matter is argued before the court, can the court ignore the same?
No, then lordship will have to have, my lord, look at the convincing materials. Because lordship is exercising a jurisdiction under 226, the court of record. Whatever is placed before your lordship, we take it as a truth, unless and until the contrary is proved.
Yes.
So there has to be contrary material. But making a statement, my lord, in my respectful submission, may not come to the help of the petitioners. Unless and until, because lordship will have to come to a finding of discrimination. Lordship will have to come to a finding of
Yes,
discrimination.
yes.
Now, in order to come to a finding of discrimination between the petitioners and other similarly situated persons, lordship will have to see the materials that so and so are other similarly situated persons, and they are also, they emerges from the same select list, or for that matter, from the same selection process. They were appointed at a prior point of time, prior to 1/2/2005. And look, these people, they have been appointed after 1/2/2005. So this is clear discrimination. Then only lordship can arrive at a finding of discrimination. Only on the basis of a submission, my lord, with all respect, my lord, on the basis of a submission.
No
that-
relief can be granted.
Yes. Whether.
Yes, Mr. Das.
Well, they have overruled the judgment of the division bench by their submission without challenging the judgment. That is their submission in short. Well, the judgment which I have shown at Annexure 11 is very clear that if the process started prior to 2005, here the process started 1996, and even if the appointment is there, but even thereafter, the benefit of full pension scheme has to be provided. And in one
No,
case,
that's all right, Mr. Das. You see, what is the contention of Mr. Borposer is that there is embargo of Rule 2A.
no, Rule 2A is different. Rule 2A will not come in the way because of the principle laid down by this court in division bench and also by the other courts. Principle is that Rule 2A is a different altogether. They have amended the rules. They have brought in NPS. This is not going to be applicable to us because, my lord, our process started. Rule 2A doesn't speak about if the process starts in the year 1996 or prior to 2005. It says, persons who were appointed after 2005, 1/2/2005, they will get the benefit of only the NPS scheme, old pension scheme, they will not get it. That's a different, but this is the mandate of the law, laid down by the division bench of this court, saying that, that new pension scheme will not be applicable if the process has started prior to that. And my lord, here in this case, I have shown, my lord, every step, my lord, they have acted, my lord, arbitrarily. Every first order which was passed in the year 2002, court said you approved the list, but they did not approve the list. My lord, they said no, the validity of the list has gone. Again, the petitioner had to come here. Then thereafter, the ultimately appointment order has been given on the basis of some undertaking. These are all forceful acts. This cannot, take away the petitioner's right which exists as per provisions of law. So in another case, my lord, I am just giving Vinoti Basumatari's case. Government take different stand at a different time, taking into consideration the facts and situation of the case. In this case, my lord, the petitioner was regularized in the year 2007. If your lordship looks into paragraph 8, they are not fair to the whole issues, my lord. Otherwise, the law proceedings would have been different. Therefore, my lord, the Honorable Supreme Court Judge recently said, don't become the mouthpiece of the, my lord, your employer. You be fair to the court. These are not, these all proceedings have come up because of the arbitrary treatment provided to the persons who are seeking justice before the court. Your lordship has seen in this case itself, 2002, my lord, court directed you approve the list. They said, no, we cannot approve the list, validity gone. My lord, the case was filed within the validity provision. it was not approved. It was not approved. The list was not approved. Where from the validity will come? Your lordship will kindly see page that 46 page. And these officers are there to this way, that way, my lord, they will not do anything. Page 46, your lordship will kindly see. I'll just read, my lord. Your lordship will just last paragraph. Hence, this petition, has your lordship got it?
Page number 46.
46, just above 6, below from below, my lord.
Hence, okay.
Hence, this petition is disposed of with a direction to the respondent, so and so, the secretary to the government of Assam and the director of education to consider and pass appropriate orders for approval of the list. And it will be above, if your lordship go till date, no approval has been communicated. In the middle, your lordship will kindly see. So approval has not been communicated. Where the question of my lord, the validity of the list expired from the day one, my lord. They have acted. If there is delay on the part of the petitioner, the lordship may deny. But here, every steps the government is responsible for treating the petitioners in this way. Now, in this case, my lord, the Minoti Basumantare's case, if she was regularized in the year 2007 or 8, government says no. It is appointed in the year 2008, regularized in the year 2008, it cannot be granted. It is under the pension scheme. May I just read the paragraph? In this paragraph 8, in this case, the basic facts are more or less admitted. There is no dispute about the fact that the husband of the petitioner was appointed by an order dated 12/3/2001 against a regular vacancy. There is also no dispute regarding the fact that they was allowed to draw statutory salary of rupees 1,800 per month, since he had not passed the junior basic training. It is admitted position of the fact late so and so was allowed to draw regular pay scale from 2007. So after having completed the junior basic training, as per Assam Service Rules 1969, a government servant would be entitled to receive pension upon his retirement from service. However, on 2009, the government of Assam in the Department of Finance had issued an office memorandum introducing the NPS, which was made applicable to the entrants in the government service after 2001 to 2005. The salient feature of the NPS scheme is schemes as appearing from the
Not necessarily. What is the ratio of the
ratio is by the paragraph 20, paragraph I think 17.
17.
Yes. For the reason stated above, I am of the view that the petitioner has succeeded in making out a good case for issuing a writ of mandamus. It is therefore declared that the petitioner's husband was not covered under the OM dated 2009 during the period of his service. Consequently, it is held that the pensionary entitlement of the petitioner's husband was covered under the Assam Service Rules mentioned in 1969 and not under the Office Memorandum 2009, which is NPS. So therefore, I submit, my lord, by submission and by not challenging the order passed by the division bench, one cannot overrule the judgment passed by the division bench of this court. So therefore, the case is very simple. The process started in the year 1996. Vacancy is of the year 1996. But ultimately, it is because of the government fault, they were appointed in the year 2011. So therefore, they are, for all purposes, they are entitled to get the benefit of the whole country.
One short reply, madam.
Yes.
I will be.
You don't get it. I get it.
Well, I will be relying on a decision.
Purnima order case is totally different.
That is, my lord.
I'm aware of.
Senior counsel was one of the my lord, appearing counsels, my lord, on behalf of the petitioners. My lord, in that bunch of cases, there the issue arose. My lord, it's a long, my lord, elaborate judgment. I will not trouble your lordship to all the parts of the decision, but lordship will find that the this honorable court of a coordinate bench, my lord, has taken into account and considered, my lord, the amendments brought to the Assam Services Pension Rules, that is Rule 2A. And whether, my lord, the petitioners therein were, my lord, were to be covered under the new pension rules or the old pension rules. And there, my lord, various categories of teachers have been called out. And one such decision, which has now been relied upon by the petitioners, my lord, that is Manati Basumatari. Lordship has just now seen it. In that decision, in that particular case, my lord, it was not a case of fresh appointment. It was a case of regularization. Petitioner Manati Basumatari was appointed prior to 1/2/2005. And petitioner Manati Basumatari, in that case, my lord, she was appointed in the capacity of a stipendiary teacher. And she had received stipend from the date of her appointment prior to 1/2/2005. And accordingly, at a later point of time, after 1/2/2005, that is the cutoff date, my lord, that petitioner, Manati Basumatari, she was regularized. And she was regularized, her services were regularized, but she was denied of the benefit of the old pension rules, that is the 1969 rules. Therefore, she came before this honorable court, challenging the decision of the state authorities, my lord, for not extending the benefit of 1969 rules, rather extending the benefit of the new pension scheme. There, the honorable court of, my lord, the coordinate bench of this honorable court, my lord, came to a definite finding, my lord, and the state has accepted it, my lord. Came to a definite finding that since the petitioner Manati Basumatari was appointed to the affairs and services of the government of Assam prior to 1/2/2005, and she continued as such, my lord, even after 1/2/2005. So therefore, that petitioner cannot be denied the benefit of 1969 rules. And here in that, my lord, decision which I have relied upon, my lord, here also lordship will find that this honorable court, the coordinate bench of this honorable court, has categorized, my lord, for the purpose of determining the issue whether, my lord, the 1969 rules will be applicable or, my lord, the NPS will be applicable. In that bunch of writ petition, my lord, this honorable court had found that the petitioners fall under defined categories of teachers. Here also the petitioners are teachers. They fall under defined category of teachers. My lord, those categories are, my lord, can be drop teachers, maybe access teachers, maybe stipendiary teachers, maybe, my lord, teachers appointed on ad hoc basis, or teachers appointed under the OBB scheme, or that kind of teachers, my lord. In that decisions which I am relying, my lord, this honorable court have extended the relief only to the stipendiary teachers and not to any other category of teachers. And that Manati Basumatari decision, which has now been placed before my lord, that pertains to the stipendiary teacher. So with regard to stipendiary teachers, there is no dispute. They will be entitled, my lord, to the old pension rules, 1969 rules, and not the NPS. But in case of all other categories of teachers, they were regularized at a later point of time. They will not be, they will not cover under the, my lord, 1969, but rather they will be covered under the, my lord, new pension rules, that is NPS. And here the striking difference is that, my lord, here the petitioners are appointed freshly, my lord, after 1/2/2005. So Manati Basumatari's decision, in my respectful submission, subject to lordship's guidance, my lord, will not come in to aid of the petitioners in the present case. That much. And here, my lord, in that decision, my lord, which I am relying, my lord, I am just, my lord, relying, my lord, more particularly paragraph, my lord, 65, my lord. Lordship may kindly see, my lord, that this, why, my lord, I am relying paragraph 65 in order to, my lord, bring home my contention that the honorable division bench decision which the petitioners are relying are, my lord, is per inquiry with regard to, my lord, vis-a-vis the amendments made in the pension rules. Paragraph 65, my lord, page 363, my lord, lordship, my lord. I am reading it, my lord. There, the coordinate bench has elaborately dealt with all the aspects. In another judgment, the Supreme Court in the case of so-and-so reported in 2014-16 XSA 350, it was observed in paragraph 19 that a decision or a judgment can be par inquirium any provision in a statute, rule, or regulation which was not brought to the notice of the court. Lordship, kindly minded, my lord. A decision may be par inquirium vis-a-vis any provision of law, rule, or notification, my lord, if that has not been brought to the, my lord, knowledge of that court, or if that decision is
No,
not.
no, the division bench has got no opportunity to deal with the Assam pension rules.
Therefore, my lord, kindly see, my lord, it was observed that a decision or a judgment can also be par inquirium if it is not possible to reconcile its ratio with that of a previously pronounced judgment of a co-equal or larger bench, or if the decision of a high court is not in consonance with the view of the Supreme Court. It
Okay.
was further observed that par inquirium rule strictly and correctly is applicable to ratio decidendi and not to obiter dicta. It is not to the obiter. It is par inquirium rule is applicable to the ratio. Therefore, I have drawn my lord's attention to the division bench decision in at paragraph 26, where direction was issued, my lord, to the
No,
central
no,
government.
in considered opinion of this court that division bench judgment cannot be treated as par inquirium.
That is my respectful submission. Par inquirium, so far as my lord, this
No,
rule is concerned, rule 2A is concerned.
No. Cannot be. Anyway,
My
heard
respectful
Mr.
submission, my lord. I'm so obliged.
Okay. Heard Mr. B. Didas, learned senior counsel assisted by Mr. Learned counsel for the petitioner. And Mr. Borpuzari, learned standing counsel for finance department.
Finance department, my lord.
And Mr. Khatonia,
Education Department.
education department. Argument concluded, judgment reserved. Anything on your part?
I'm
Subscribe him. Okay.
Deeply obliged.
I'm so obliged, my lord.
Taking pain to hear them.
Coming out of entry.
Yes, Mr. Gupta, what
My lord,
instruction is available with you?
my lord, instruction is available, but I have given the. My lord, here, this is the, my lord, SOP regarding conduct of examination. My lord will take page number 7. 7 clause F. My lord. No, this says, my lord, that RIMC will maintain an additional strength of 2% to cater for withdrawal resignation of cadets at different times of the term. However, in spite of additional strength, if the RIMC needs to admit cadets in between the term, then the cutoff date for Jan term will be 1st May, and for July term will be, my lord, 1st of November. So, my lord, meaning thereby, my lord, that they can be admitted, my lord, for the July term till November, there is a time.
Yes.
In between, they can be admitted. And my lord, secondly, regarding the.
Now tell me, what is the obstacle in giving admission to him?
Yes, my lord, there is no, I think no, there is no obstacle now because I have again clarified. My lord, from the list, my lord, because my only concern was, my lord, whether who was the last, my lord, category candidate, reserve category candidate, and what is the mark secured. So I have just obtained the instruction, my lord, that at point number 3, they have stated that the marks secured by the last reserve category candidate in the list of 28 candidates who cleared medical tests. Mr. Atharva Agarwal from MP is 54.25. That is what I have earlier submitted. Now, other reserve category boys who were declared fit in medical but not come in the order of seniority for admission. My lord, the first name is of the petitioner.
Ah,
So, now, my lord, since this, one of the candidate has withdrawn, he will come within the zone of consideration
yes.
from the 28 seats. My lord.
Ask them then to admit him.
My lord,
Hmm?
my lord, give them, I will
Hmm.
instruct them, my lord.
So if there is no obstacle in admitting him, you admit him.
My lord,
We are not disposing of this as a petition. We are not also passing any order. We will keep it pending.
my lord.
You admit him and thereafter you inform this court that he is admitted,
My lord.
right?
Hmm.
So,
Lordship will fix a date then, my lord, after
yes.
vacation in the meantime.
Yes.
My lord, instead of 10 to 15 days will be given, so that the petitioner will report in the office, my lord.
No, we are not passing any order. Huh? We ask him to comply. We ask him to admit him.
Within a period.
Yes.
Then they
Oh, no,
will
we
issue a-
also not pass any written order.
My lord.
It is the verbal instruction of this court.
My lord.
There is no obstacle in.
That will be reported, my lord. No, sorry, my lord. That will be recorded, my lord, in the order.
No, I will.
Okay, my lord.
We are conveying the desire of the court
My lord.
to you
My lord.
that admit him.
My lord.
Then you inform this court on next date. We take it up on
Immediately
21st,
on
then?
the reopening.
21st.
21st,
My lord. My lord.
right?
My lord.
Or we'll pass order.
No, my
You
lord.
see, if we pass order, it may be embarrassing for you also.
My lord. No, I will instruct, my lord, immediately on the reopening. In the meantime, my lord, if it is done. it
But
will come.
don't come with any other excuse.
No, my lord, no, I have.
My lord, one
Clear,
prayer,
my
my lord. The matter will be kept further in this case, my lord.
Okay.
Yes.
But the parties are represented by the English council. Heard in part, list the matter again on 21st October.
Coming item 22.
Yesterday, your lordship was.
Anyway, the documents submitted by you will be part of the record.
Part of the report.
During hearing, Mr. Gupta has produced 2 papers before this court, which shall be part of the record.
My lord.
Yes, Mr. Das.
Yesterday, your lordship was pleased to check me one judgment. I have checked out few words we have given there, and I find out that judgment regarding the tankers.
Use of vehicle.
Yeah, use of vehicle, it is absolutely.
Yes.
Itu আগতে 139 document আছিল 92
So this judgment was based on the decision of another judgment. In Shivaji, judgment is so what we have to see whether that no, whether in that case the claim petition was filed under section 163 capital A or under section 166
It
MD.
was, as it is mentioned, my lord, 139 Act, Motor Vehicle Earlier Act, and it is my lord, 1110 and 92 Act, it is mentioned. This in term, my lord. Paragraph 19 to 21.
No, this this Shivaji Doyano Patil case.
Yes, my lord. Oh, yes, my lord, I have to.
Hmm? Wait, can you find out this judgment?
Worship.
91.3 SCC 530. 91.3 SCC 530.
ইয়াতে ওলাব পাৰিম।
Shivaji Dayano Patil. Okay, 22 pages.
20 it out.
Yes, sir.
Both side. SSC নবলে
এনেকে ডাইৰেক্ট পোৱা নাযায় ইণ্ডিয়া
সেইটো অলপ বেলেগ হয়। Okay, madam, anything you want to submit?
Well, Lordship, they filed the application under 166 of the NBL.
Hmm.
In their claim petition, they pleaded that to save the save cow, the accident occurred. And in they they exhibited the FIR. In the FIR, it was clearly stated to save the cow, accident occurred. And in the charge sheet, in the final report, no negligence was found against the driver. And they examined the IO. IO in cross examination also admitted that there is no negligence on the part of the driver. Therefore, since they filed the claim application under section 166 of the NBL, it is their duty to prove that there was a rash and negligence driving. Otherwise, the claim application under section 166 is not maintainable at all. And accident occurred, it is true, but it is the use of the vehicle. And in that case, when it was use of the vehicle, claim application is to be filed under section 163A of the NBL. That they did not file. Therefore, claim application is not. I have a judgment in this regard. Supreme Court judgment is there. Your Lordship, may, in 2007 5 SCC, forthwith, paragraph number 27.
Yes.
We think that the law laid down in Minubi Mehta versus Balkrishna Ramchandra Nayan was accepted by the legislature while enacting the Motor Vehicles Act 1988 and introducing section 163A of the Act, providing for payment of compensation, notwithstanding anything contained in the Act or in any other law for the time being in force, that the owner of a motor vehicle or authorized insurer shall be liable to pay in case of death or permanent disablement due to the accident arising out of the use of the motor vehicle. Compensation is indicated in second schedule to the legal heirs of the victim as the case may be, and in the claim made under subsection 1 of section 163A of the Act, the claimant shall not be required to plead or establish that death or permanent disablement in respect of which the claim has been made was due to any wrongful act or neglect or default of the owner of the vehicle concerned. In 163 Act, there is no necessity to prove the negligence. Therefore, the victim of an accident or his dependents have an option either to proceed under section 166 of the Act or under section 163A of the Act. Once they approach the tribunal under section 166 of the Act, they have necessarily to take upon themselves the burden of establishing the negligence of the driver or owner of the vehicle concerned. But if they proceed under section 163A of the Act, the compensation will be awarded in terms of the schedule without calling upon the victim or his dependents to establish any negligence or default on the part of the owner of the vehicle or the driver of the vehicle. Then, Your Lordship, 2012 Code SPC 552. Paragraph number 6. The learned counsel Sri S.L. Gupta appearing for the responding insurance company would submit that since the petition was filed by the parents of the deceased person was under section 166 of the Act, the entire responsibility of proving the act of rash and negligent driving by the driver of the vehicle was on the claimants, and since that was not done by adducing cogent evidence, the courts below were justified in rejecting the claim petition filed by the appellant claimants under section 166 of the Act. In 8 of his submission, the learned counsel has drawn our attention to the observation made by this court in Oriental Insurance Company versus Minavel. Having heard the learned counsel for the parties to this list, the question that would arise for our consideration and decision is whether the parents of the deceased are entitled to the payment of compensation under the provision of the Act by the respondent insurance company. In order to answer the issue that we have framed out for ourselves, the facts in brief requires the claimants are the parents of the deceased person. The deceased was a doctor by profession. The deceased was traveling in the motor vehicle driven by respondent number 1, who happens to be a close associate friend. It has come in the evidence of the claimants as well as respondent that the vehicle in question was not driven in a rash and negligent manner by the respondent number 1. Admittedly, the petition filed by the claimants was under section 166 of the Act and not under section 163 of the Act. This is not in dispute. Therefore, it was the entire responsibility of the parents of the deceased to have established the respondent number 1 drove the vehicle in a rash and negligent manner which resulted in the fatal accident. Maybe in order to help respondent 1, the claimants had not taken up the plea before the tribunal. Therefore, the High Court was justified in sustaining the judgment and order passed by the tribunal. We make it clear that if for any reason the claimants had filed the petition under section 163A of the, then the dicta of this court in Kasturba Begum would have come to the assistance of the claimants. And the learned tribunal has relied upon one judgment of the Honorable Guwahati High Court. In that case also, it was there's 166 in under.
No, that is well settled that in a petition under section 166, one has to establish rash and negligent driving. But whether the trial court has properly appreciated the evidence on record?
No. Because it is their evidence. They pleaded that there is a rash and negligence driving in the claim petition, and in the written statement we have denied that we have denied the rash and negligence driving, and they have adduced the evidence. We did not adduce anybody.
Whether any police case was registered or not?
Yes.
UD case was registered.
UD case.
UD case
Yes, it was registered, my lord, but it was ultimately after findings that report has been it is
final report has been given, and they have called the IO. And the IO cross-examination admitted that
On what basis final report was submitted?
because they did not find any rational negligence driving of the owner cum driver of the vehicle. And the owner cum driver of the vehicle, that was final report was given, and they called the IO to prove the
Whether
accident.
that final report is part of the record.
Yes, they had exhibit 5.
Hmm.
In the FIR also, it was stated that in order to save the cow, the accident occurred. It was also, they also, from their exhibit, it was reflected that there was no rational negligence driving. And they adduced the evidence of IO. IO in cross-examination clearly stated that there was no rational negligence driving on the part of the owner cum driver of the vehicle. They clearly,
That may be, but the IO's evidence is not final.
Yes.
they have to
Because his evidence is based on only on the statement given by the witnesses examined by him
Area
under section
was not
160.
examined on their part.
Pardon?
They failed to adduce any eyewitness.
Hmm. And the question is whether there was any eyewitness or not.
Yes, as per final report, it was stated that from the evidence of the other witnesses, the final report was come to the conclusion that there was no rational negligence driving on the part of the driver of the vehicle. They failed to adduce any evidence of the eyewitness.
Okay, we'll see. Heard Mr. H. Das, learned counsel for the appellant, and Madam
That's right.
S. Roy,
For
learned,
the respondent number 1.
standing counsel for the respondent number 1.
In the High Court judgment, which was reflected in the tribunal, the case was remanded back to decide the claim petition under section 163A of the NBL.
That option is there, but we'll see whether any relief can be granted under section 166 of the MBA. Because there is one judgment, I don't know whether it was Supreme Court or High Court, where it is stated that if a police case is registered, then it is sufficient to hold that rational negligent driving is there.
Yes.
UD case was registered.
Maybe.
But case was registered. No?
But
one case has been registered.
but their evidence was not sufficient.
We'll see. Okay. Judgment reserved.
One thing, if your lordship may remand the matter, then I have two submissions for their negligence. The insurance company may not be liable for the interest which were from the date of the filing of the claim petition. And another thing, 40,000 was awarded, and it was deposited by the learned at the award. If you know about trials, 40,000 will be adjusted.
No, that will be there definitely. Whatever you have paid, that has to be adjusted from the final payment.
Against her contention, I have also some judgment regarding that point, my lord, whether this is necessary. Strict proof is not necessary, my lord. Negligence has to prove it is the duty lies upon the only claimant. So I'm also placing the judgment.
Next item.
Number 4, pending matter.
So I received the objection copy also. The last question also, whether how many witnesses were examined, that's why the report was called for the High Court also. To examine this till date lordship, 2 evidence examined. And
how many witnesses were cited? 8 witnesses.
8 witnesses. Lordship.
Out of 8, 2 examined.
2 examined lordship. And total days lordship, 1,067 date lordship. And I'm getting from the objection lordship that they have just pointed out 2 things that lordship. One thing is that lordship, whether I something is recovered from myself or not lordship. Here in this case lordship, seizure list was on lordship on 6/10 lordship. I was arrested in this case after the call of the seizure list lordship. That is 23/10 lordship. Now in this case lordship, here the delaying is that lordship. I was arrested in this case on 23/10 lordship 2021 lordship. After that lordship, the several It's a long period of the time, lordship. There were very long time, lordship. The court was vacant, lordship. This is what also having a reason of the delaying in that, lordship. Now, in this case, lordship, I'm borrowing the section 37, lordship. I have a case of Ravi Prakash, lordship. They're very clear on page number 98, lordship. On page number 98. 98, lordship. There's a clear that in the case of Ravi Prakash versus the state of Odisha, the Supra lordship, it's clear that the embargo of the section of 37 is not in that, lordship. If the case comes out, yes, there is a delay in the trial court, lordship. It's observed by the Supreme Court of India, lordship, in this case. And one thing should again it comes out that, lordship, in the case of Bharat Chandra versus Union of India, lordship. Bharat Chandra, in that, lordship, one matter was quashed in this case, lordship. In this case, lordship, on page number 7, lordship, in my paragraph, lordship. In this case, lordship, in this case, lordship, this comes out, lordship, if anything should be not recovered from the accused person, lordship, then it comes out. Again, is a representative Tufan Singh also cases that, lordship. And depending upon that, lordship, may I read the page number 7, lordship, the below part, lordship. In similarity, choose the case of Bharat Chaudhary versus of India, reported in 2021 Supreme Court online, Supreme Court 1 to 3. But the apex court held that in the absence of any psychoactive substance found in the conscious possession of A4, we are of the opinion that may reliance on the settlement made by the A1 to A3 under section.
No, Mr. Dubey,
Yes, lordship.
whether that judgment is available with you, Bharat Chaudhary.
No, lordship, but
And have you gone through that judgment?
lordship, here, lordship, I have not right now the judgment, lordship, but
No, tell me whether you have gone through that judgment or not.
not properly, lordship.
Not properly. But how can you refer the matter in the application?
Also, because on having the low part, lordship, that is the vast, lordship. Yes. Also, other things, lordship, I have annexed here, lordship. There is on having a, I have annexed an order also, order copy also there, lordship, on page number. This is the order of this honorable court, lordship, Guwahati High Court, lordship. Just on the basis of the non-detention of the lordship, they get the benefit of the bail, lordship.
No, in the case of Bharat Chaudhary, there was no recovery from the position of the accused.
Yes, lordship. In my case also same, lordship. Nothing is recovered from my possession, lordship. Nothing has been recovered from my possession, lordship, because already the seizure list was, lordship, because on 6/10, lordship, and I was arrested in this case on 23/10, lordship. Only my name should come in this case, lordship, by having the conventional instrument 57 of the NDPS, lordship, and the CDR, lordship. They stated in the objection also, their lordship, that I stated in my confidential statement that, lordship, by referring to some other person also name is their, lordship. But it is the central principle of the law is that, lordship, confidential statement not assumed in the court, lordship. Just on the basis of
Then
that,
CDR?
lordship, CDR, lordship.
Why should we ignore the CDR?
In CDR, lordship, only having a thing that, lordship, I will have a just call details should be comes out there, lordship. But here also there, lordship, just having a none is confirmly addicted, lordship. If that very persons I know him. If I am know that very person or any person, lordship, this should not becoming that I am also involved in that case, lordship. My only having a submission in this case, lordship, on having a just on I have an action order there, lordship, on the based of the length of the detention, lordship, and the delay in the trial, there, lordship. Because Article 21 of the Constitution is the bulletin here also there, lordship. So embargo section 37 is not involved in this case, lordship. 1067 days, lordship, I am behind the bar, lordship. Only 2 have the witness examined in this case, lordship. In page number 98 also there, lordship. This is a part of one para, lordship, in the order dated, lordship. The order of the
You produce the judgment, not referring to the orders of this court.
Yes, Lordship.
This is not the way of arguing before the court. Without the judgment, you are referring here and there. You do not know even what was the discussion in the Bharat Chaudhary case, but you are referring the same in this case. And submits that the same is applicable in your case. Hmm? What is your objection?
Your Lordship, we have filed our objection. Your Lordship, please come to page 105 of objection, para 3. May I read, Your Lordship? Page 105, para 3.
Yes.
That during investigation and on the basis of corroborative evidences of the arrested accused persons who had been intercepted and arrested, along with the seized 426.910 kg ganja in the instant case, the name of Achelal Sahani, the present petitioner, came out as the main conspirator as well as the kingpin of the trafficking of the ganja in the instant case, who planned and managed the whole conspiracy in illegal trafficking of the seized contraband in the instant case. Now, Your Lordship, para 4. That on his voluntary statement recorded under 67C of NDPS Act 1985, Achelal Sahani confessed his guilt, and on the basis of his confessional statement, CDR analysis and other corroborative evidences given by him, Achelal Sahani
No,
was
that's all right, but whether 67 statement given by the accused under section 67 of the NDPS Act is can be treated as evidence. Can you rely upon the same?
Your Lordship, please come to para 5. Your Lordship, the accused.
You answer my question. Whether voluntary statement can be relied upon in view of the decision of Tufan Singh?
No, Lordship.
Have you heard the decision of Tufan Singh?
Yes, Lordship.
Then why you have put this sentence here in your objection? Apart from CDR, what other materials against him? You are not aware of.
I'm not aware.
Then why you are appearing?
Lordship, because my senior is on leg.
You ask your senior to remain present.
Lordship.
Mr. Dubey, you go through the judgments you have relied upon, and you tell this court how those judgments are applicable in the case. We are not disposing of the petition. We will take it up on 21st of October. You carefully go through the judgments. You tell this court how the principle laid down in those cases are applicable in your case. Merely referring a decision or some sentences here and there will not help you. You come prepared. Heard in part, release the matter on 21st October. Both the parties are represented by the NDP.
Have your list.